already scheduled?
I believe so, yes.
All right, Ms. Collins, the doctors are going to interview you, okay? Sit tight for a little while.
All right.
Yeah, my only grief is that it takes 90 days, and I don't know why.
I understand, Your Honor.
I've been complaining about that for 40 years, but,
wish it
seems
was
to
sooner.
still happen. Okay. All right, I think we're ready to call the interpreter.
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter. The interpreter has already been sworn.
Thank you very much. We have two cases, I think, including a Mr. Delorso Garcia, and also a witness in this case. It's case number 2021 CF 2552AO. Counsel, it's going to Division 14. Does the witness need an interpreter?
Yes.
Okay. Our witness needs the interpreter too. He has a private attorney?
¿Él tiene un abogado privado?
Yes, Your Honor. Rolando Sanchez.
Sí, su señoría, Rolando Sánchez.
Okay. In this particular case, it's alleged that he violated a pretrial release on a witness tampering case involving an alleged breath test of .187 on April 3rd, and Judge Strobridge already denied a motion to quash the warrant in regard to the violation of the pretrial release condition. So I'm not sure I really have a whole lot to say about the matter, because that judge already evidently looked at this. State wants to say something. Oh, wait, I'm sorry, interpretation.
En este caso, se le acusa de haber incumplido con las condiciones de libertad provisional ante una acusación de intimidación de testigo. Se alega que hubo un resultado de una prueba de aliento de 1.7. En este caso, ya el juez Strobridge había negado retirar la orden de arresto por haber incumplido con las condiciones del régimen de libertad provisional. Yo no creo que yo tenga mucho que añadir en esta situación, ya que este juez ya analizó el caso.
Yes, Your Honor. I'm looking at notes. There was a hearing yesterday, the 24th, regarding a motion to modify the no contact order. It was denied due to the victim still not wanting contact.
Sí, su señoría, ayer hubo una audiencia en la cual se solicitó que se modificara la prohibición, la orden de prohibición de contacto. Esta solicitud fue denegada porque la víctima aún no desea tener contacto.
I also have notes from that motion to quash the capias ruling. And I see that the judge instructed that the defendant needed to turn himself in and they can later file a bond motion.
También recibimos notificación acerca del resultado de la solicitud para eliminar la orden de arresto, y creo que se le dijo que él podría presentar posteriormente una solicitud para que se le imponga una fianza.
Due to that being Judge Strobridge's ruling yesterday, state would just ask that you hold him no bond so Mr. Sanchez can file a bond motion so this can be heard in front of Judge Strobridge again.
Nosotros solicitamos que se imponga prisión preventiva para que se pueda cumplir con la orden del juez Strobridge ayer de que se solicite una audiencia para fianza.
I would assume that your lawyer is on top of this and can get a full hearing in regard to your bond motion within a few days.
Yo presumo que su abogado ya está trabajando con esto y que él podrá conseguir que se le conceda una audiencia para establecer una fianza en unos pocos días.
And I know better than to second guess these felony judges.
pero no quisiera contradecir a estos jueces.
Ma'am, since you're here, was there something you wanted to say?
Señora, ya que usted se encuentra aquí, ¿hay algo que usted desea decir?
Bueno, no, sencillamente que pues, me gustaría que todo esto resulte lo mejor posible. No deseo verlo preso para nada. Él es pues, muy buena persona, pero tristemente pues, tiene una enfermedad que es alcoholismo. Y me gustaría la mejor ayuda posible para él, por supuesto.
No, I just want to say that I want the best outcome possible. I don't like seeing him in jail, but he does has an illness. He has an alcohol addiction. So I would like for him to get help.
Okay, well, you could talk to the state, and you could probably talk to his lawyer and tell them what your preferences are, because the court certainly is concerned about that. I'm just going to wait and let the trial judge make the real decisions on this.
Señora, usted puede conversar con la fiscalía y probablemente también con el abogado de él para dejarle saber cuáles son las preferencias que tiene usted en cuanto al resultado de este caso. Yo, por lo pronto, voy a esperar para que sea el juez designado al caso quien se encargue de tomar las decisiones.
Your Honor, state would just ask for him to maintain the condition of no contact with the victim.
Su señoría, solicitamos que se sostenga la prohibición de contacto con la víctima.
Right, nothing prevents her from talking to his lawyer and with the state in order to get her concerns noted for the record. And that's all we have for today. You're in good hands with your lawyer's representation, sir.
Sí, pero nada previene que ella se comunique con la fiscalía y con el abogado de él para dejarle saber cuáles son las preferencias de ella. Muy bien, entonces esto es todo por hoy, señor. Usted está en muy buenas manos con su abogado.
So that's staying at no bond, Your Honor?
Sure, good luck to you both. No, taking no action right now. Thank you.
Buena suerte a ambos. No se tomará acción en estos momentos.
Yeah, go ahead. Thanks. Okay, is this Mr. Rivera Torres?
Sí, correcto.
Thank you, sir.
Yes, correct.
Enough. Ma'am, we have a witness here. This is case number 21MM354480. Does the witness need an interpreter? Okay. All right. In this case, Mr. Rivera Torres,
En este caso, el señor Rivera Torres
is charged with domestic battery.
se le acusa de agresión física, violencia doméstica.
We do have a witness.
Tenemos un testigo presente.
Let's get her sworn in to testify.
Señora, ¿desea usted testificar esta mañana?
Sí.
Could you
Yes.
raise your right hand? Do
Por
you,
favor, levante la mano derecha.
do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Y promete decir la verdad, solamente la verdad y nada más que la verdad.
Yes.
All right, you can put
Yes.
your left hand down. Thank you.
Gracias, puede bajar la mano.
Your Honor, may I inquire?
Sure.
Su señoría, ¿puede hacerle algunas preguntas? Sí.
Good morning, ma'am. Can you please state your name for the record?
Amy Román
Buenos días,
Ramos.
¿podría por favor decir su nombre para que conste en actas?
Amy Román Ramos.
All right, thank you. And what is your relationship to Mr.?
I'm sorry, I couldn't hear her name.
Amy Román Ramos.
Roman Ramos.
And what is your relationship to Mr. Rivera Torres?
¿Qué relación tiene usted con el señor Rivera Torres?
Somos pareja.
We are a couple.
Okay. Approximately how long have you known him?
¿Aproximadamente cuánto tiempo le conoce?
Un año.
1 year.
Okay. And has anything like this ever happened before?
¿Algo similar a esto había sucedido en el pasado?
En algún momento sí.
Sometime, yes.
Okay. Approximately how long ago would you say the last time was?
Aproximadamente, ¿cuánto tiempo diría usted que pasó desde el último incidente?
No me recuerdo cuánto tiempo ha pasado.
I don't remember how much time has passed.
Okay, thank you. And are you afraid of the defendant?
Muy bien, gracias. Señora, ¿usted le teme al acusado?
No.
No.
Do you want to have contact with him?
¿Usted desea tener contacto con él?
Sí.
Yes.
Okay. And if anything like this ever occurred in the future, would you feel comfortable calling 911?
Si algo como esto volviese a suceder en el futuro, ¿se sentiría usted cómoda llamando al 911?
Sí.
Yes.
Okay. And do you believe drugs or alcohol were involved in this incident?
¿Piensa usted que las drogas o el alcohol estuvieron involucradas en este incidente o tuvieron algo que ver en este incidente?
De verdad no sé.
I really don't know.
Okay, thank you. That's all I have, Your Honor.
Muy bien, gracias. Son todas las preguntas que tengo, su señoría.
Okay, thank you, ma'am.
No questions, Your Honor.
All right.
Muy bien, gracias, señora. ¿Puedo preguntar? Sí.
We can appoint the public defender to represent Mr. Rivera Torres.
Podemos designar al abogado de oficio para que represente al señor Rivera Torres.
There is enough information for the charge of domestic battery to be filed.
Hay la información suficiente para que se radique la acusación por agresión física, violencia doméstica.
We also have information that there was a prior arrest for a similar situation about a month ago in regard, I think, to the same parties.
También tenemos información de que hay un arresto previo por una situación similar aproximadamente hace un mes con las mismas partes.
Your Honor, that ag bat on a pregnant person was the same victim, and that occurred in August
Okay.
of 2020.
All right.
Sí, su señoría fue la misma víctima. Eso ocurrió en agosto del 2020.
What does the state want to say?
Your Honor,
¿Qué desea decir la fiscalía?
in regards to contact, I understand the victim's testimony here today that she would want contact and she is not afraid of the defendant. However, given the DV history that's listed on the face sheet, the aggravated battery on a pregnant person, and the battery by strangulation, there seems to be a significant history between this defendant and this victim. And given that they have a new baby, I'm concerned for the continued violence between the two. So at this time, I would ask for a no contact until a hearing can be heard later on regarding if that contact is safe, notwithstanding the victim's input here today.
Su señoría, en cuanto al contacto entre las partes, a pesar de que la víctima ha dicho que sí desea tener contacto, a nosotros nos preocupa el historial de violencia doméstica entre las partes, debido a que hay ya un incidente previo de agresión física por violencia doméstica contra una persona embarazada y ahora por estrangulación. Hay un historial significativo de violencia doméstica entre las partes y a nosotros nos preocupa la violencia que ha continuado. Ahora hay un bebé también en la situación, por lo tanto nosotros vamos a solicitar que se le prohíba el contacto entre las partes hasta que se pueda celebrar una audiencia en la que se determine si este contacto es seguro o no.
Your Honor, if I may, I understand the state's argument, but the victim is testifying that she would like to continue to see Mr. Rivera Torres also. I don't believe our client would have anywhere else to go if there was a no contact order issued. He does also qualify for PTR, so I would have you consider that in your order.
Su señoría, nosotros entendemos la posición de la fiscalía, pero la víctima ha indicado aquí que desea tener contacto con el señor Rivera Torres y también él no tendría otro sitio a donde ir si se prohibiese el contacto entre ellos. ¿Cree cualifica o cumple con los requisitos para que se le ponga en libertad bajo el programa de libertad provisional?
Does anybody know if Department of Children and Family Services has been notified yet?
¿Alguien sabe si esto se le ha notificado al Departamento de Niños y Familias?
I'm not sure, Your Honor. It doesn't. I don't
No
think
estoy
it-
segura, su señoría.
I do not think it mentions it in the report. I believe the victim is indicating that they have been.
Yes, ma'am.
No creo que el informe lo mencione, pero creo que la víctima está indicando que sí se les ha informado.
Is the Department of Children and Family Services involved yet, ma'am?
Sí,
Señora, ¿el Departamento de Niños y Familias ya está involucrado en el caso?
Okay, and
Yes.
the reason for that is, a baby is exquisitely affected by violence in the home.
La razón por esto es porque al bebé, esta violencia en el hogar le afecta.
And so it's extremely important that this child be protected from violence.
Y por lo tanto es extremadamente importante que este menor sea protegido de la violencia.
The impressions on the child's brain at this time are enormous.
Las impresiones que se forman en el cerebro del bebé en estos momentos son enormes.
So I understand that you are concerned he has no other place to live.
Yo entiendo que usted esté preocupado porque él no tiene otro lugar donde vivir.
And you also want for him to become the man that you dream that he will become now.
Y usted también desea que él se convierta en el hombre que usted sueña en el que él se convierta.
Having had more than 40 years of experience in this field, I know that you will probably put up with this about 6 times before you give up.
Pero teniendo ya 40 años de experiencia en este campo, yo entiendo que usted aproximadamente le dará 6 oportunidades antes de rendirse.
And I understand the concerns of the state. I also understand that you're probably going to let him back in anyway, notwithstanding any court orders at this time.
Entiendo la preocupación de la fiscalía y también entiendo que probablemente usted le abra las puertas nuevamente haciendo caso omiso de las órdenes que podría dictar el tribunal.
And I don't wish to create a situation that you're going to ignore court orders.
Y yo no quiero crear una situación que la haga a usted ignorar las órdenes del tribunal.
So I'm simply going to tell you, after 40 years of looking at these cases, ma'am,
Así que, señora, yo le voy a decir que luego de 40 años de atender este tipo de casos,
hopefully he grows out of this, but in my experience, that doesn't always happen, and at some point, you may need to decide to protect yourself and most importantly, the brain health of your child.
y le voy a decir que lo mejor sería que la persona saliese o dejase atrás, madurase y dejase atrás este tipo de conducta, pero esto no suele suceder todo el tiempo y en algún momento usted va a tener que tomar la decisión de protegerse a sí misma y, más importante aún, de proteger la salud mental del niño.
And another thing a child learns from this is that this is normal, and so they end up repeating the same patterns, and so basically that is one of the
Lo otro
worst
es-
things that results from this.
Lo otro es que también el niño o la niña aprende de esto, que esto es una situación normal y lo peor es que termina repitiendo los mismos patrones de conducta.
So I think the interviewing staff at the jail indicates that based on his record, he does qualify for pretrial release at this time.
Creo que las personas que le hicieron la entrevista en la cárcel, el equipo de trabajo, dicen que según la información prestada, él cumple con los requisitos para que se le conceda libertad provisional.
All right.
Sí, su señoría.
All right. Will allow pretrial release, will require no hostile contact.
Muy bien, entonces se concede la libertad provisional y se permite el contacto entre las partes siempre y cuando sea sin hostilidad.
Also, that Mr. Rivera Torres must follow the requirements of the Department of Children and Family Services and any juvenile court orders in relation to his contact with the baby.
También el señor Rivera Torres tendrá que seguir las instrucciones y las recomendaciones del programa o del departamento, perdón, de niños y familias y cualquier orden que le dé el Tribunal de Menores en relación a su relación con el bebé.
Any violation of those orders will also be a violation of your release conditions, subjecting you to having your pretrial release on this case revoked.
Cualquier incumplimiento con esas instrucciones y esas órdenes constituirán un incumplimiento con las condiciones de la libertad provisional, en este caso, lo que le haría a usted tener que regresar a la cárcel.
One last thing, ma'am. The worst thing that really happens if he has to be on probation for this is that he has to take a 6-month course to help him with his anger management issues.
Señora, algo más. Lo peor que puede pasar si él termina en régimen de libertad vigilada es que va a tener que tomar un curso de 6 meses de manejo de la ira.
So, sir, I know you're only working part-time and being on probation and paying for this course costs money, but for the love of God, if you're ever going to grow into a real man and get a full-time job and do the work to get through this course, which at least 50% of the time is effective, now would be the time.
Y, señor, yo sé que usted está trabajando a tiempo parcial, pero por el amor de Dios, si en algún momento usted se va a convertir en un hombre de verdad y decide tener un trabajo a tiempo completo y participar de este curso y completarlo, este curso solamente funciona en el 50% de las veces, este sería el mejor momento para hacerlo.
Good luck to you both.
Buena suerte a ambos.
Thank you very much, Madam Interpreter.
Thank you, Your Honor.
Okay. We don't have a bunch of move-ups and stuff?
No, we just had
Cool. All right, is this Mr. Dow?
Yes, Your Honor.
All right, thank you, sir. We have case number 2021-CF6089. It's going to Division 14, Counsel. We can appoint the public defender to represent Mr. Dow. In regard to this case, sir, they had enough information to at least file the charge of child neglect, possession of firearm by convicted felon, and failure to safely store the firearm. I know you're probably already suffering a lot of grief over this.
Yes, ma'am.
Don't have to say anything. So the jail staff correctly upgraded the bond to 0, at least pending this hearing now. And I see that you have some criminal history, sir, but also I think the main question right now is just to follow the requirements of the Department of Family and Children and Juvenile Court, whatever they order in regard to contact with the child.
Yes, ma'am.
And the relatively otherwise normal bond amount for this would be $2,500 on count 1, the neglect, 150 on counts 2 and 3, possession of firearm by convicted felon, and failure to safely store. So, once you get out, follow those. I'm pretty sure DCF
Yes.
was contacted. So follow those requirements, and those are the same requirements for this case. Violation of those requirements would also violate your release conditions on this case. All right, public defender is appointed. Yes,
They
ma'am.
would request no weapons, firearms, or ammunition.
Okay, no more weapons around the house. If this isn't enough to make you get rid of them, I don't know what is. Good luck, sir. All right. Good luck to your child. Okay, is this Miss Garcia?
Yes, ma'am.
All right, thank you, ma'am. We have case number 21 CF 6081, Division 14. Public defender is appointed. And we have a witness, sir. Would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you very much. State wants to ask you some questions about safety.
Okie dokie.
All right.
Good morning, sir. Can you please state your name for the record?
My name is Noah May.
Okay. And what is your relationship to Miss Garcia?
I'm her boyfriend / husband because we live together. So it's like, yeah.
Okay. And approximately how long have you known her?
I've known her about 8 years, but we've been together now for about 1 year and 4 months.
Okay. And has anything like this ever happened before?
I mean, honestly, I just see it as a fight. Like, it's just another fight. Like, yeah, things do get, heated in an argument. And I mean, hey, I took a hit. And honestly, if I could not have her in here, I wouldn't. I don't like seeing her in here.
Okay. And are you afraid of her?
No, not at all.
Do you want to have contact with her?
I would like it.
Okay. That's all I have, Your Honor.
Okay,
No questions, Your Honor.
all right. Well, she otherwise qualifies for pretrial release.
State has no objection, Your Honor.
All right, no hostile contact. We're not as worried about this one. In regard to, I find probable cause in regard, it's called ag battery, but we'll go with the pretrial release. We think that it might actually have been an accident with a shovel. And make sure you all, the state has some standard requirements that they want put on the orders. If you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of your release. No weapons while you're out on bond or pretrial release. And no hostile contact means no fighting. Sir, it's interesting that you evidently anticipate this as a normal aspect of relationships.
No, I mean, I don't. It's just like the way it went down, it was more of like a back and forth argument.
Uh-huh.
And then it led to, obviously the hitting and stuff like that. But like, it wasn't nothing like, obviously we were yelling at each other and I got up in her face as she did to me. So, I mean,
Uh-huh.
it was just a, one-on-one argument that
So,
I
well,
believe that
these
no one else
things
should have.
test your ability to manage relationships and, especially since you've already started to refer to yourself as a husband, you might want to look a little deeper into those things, because otherwise you may not be able to maintain relationships. I mean, it's not that you can't have disagreements, it's a matter of how you deal with it, what kind of unconscious issues are happening to make it more explosive, and so I just recommend that to you.
Oh, yeah,
right?
for sure. I will-
Otherwise, because this, it doesn't have to be this way. It could actually be, serene and calm most of the time.
Yeah,
That's actually a real possibility in life. So good luck with that.
I appreciate you.
You're welcome. I
Thank you.
appreciate you too. Thank you for coming down. Good luck to you both.
Thank you.
All right. All right, we have Ms. Summer Reed. And Ms. Reed, the case number is 2021 CF 6091. It's going to Division 12. Let's appoint the public defender to represent Ms. Reed. In this case, there's a little complicating factor because she's out on bond. So we have to deal with that also. In regard to the thing that allegedly happened yesterday, it's alleged that she committed an aggravated battery with a deadly weapon by grabbing a steering wheel, and which resulted in the other party losing control, hitting the curb, breaking a tire and a fender. It's enough to at least file the charge, ma'am. I'm going to take that all in consideration in regard to the bond. Since the other person is not here, will require no contact, separate residence. I don't remember if you had a residence together, but if you did, will allow you a one-time police escort to get things out of the residence if you were living together, until a judge can hear from both parties and make sure that it's safe. And you would talk to your lawyer about arranging for a hearing in regard to that. A hearing can be set up fairly quickly in regard to modification of release conditions. So we'll give you the name and address of the public defender. In regard to the bond, I'm okay with it. I've got a number in mind. Did you all wish to talk about that?
If I may, Your Honor, the only thing I wanted to note was the notes from our office have Ms. Reed and her attorney resolving those cases at this moment. So I would have you take no action on that to prevent any complications from that resolution.
Your
Are you
Honor.
talking about the Bat Leo?
The out on bond case, yes, Your Honor.
Your Honor, the state would object to that. She was out on bond for a bat DV with the same victim that also turned into a bat Leo and a resisting without. It's the same victim in that case as it is in this case, showing a pattern of behavior. I don't think it's reasonable to not take action on that case, as it is the same victim and relatively the same charges that she's picking up while out on bond, violating that bond.
Right, I looked up, I found some things on it. It looks like, I'm not sure that the state filed on the Bat DV.
We did, Your Honor.
You
Filed
did?
all three of those charges.
She's out on PTR, at least on the Bat Leo and the resisting. I wasn't sure about the other battery. And I noticed that there's a mental health status hearing set. However, I didn't see any, well, I probably could have stayed on the screen longer. I didn't really see the request for a mental health status hearing. I didn't see any reports yet. And so I don't know what the concerns are. So I was thinking of this. I was thinking about requiring an alternative, which I don't know if she qualifies for or not. 1,000 on each, the new and the old, or mental health pretrial release if she qualifies. Because if they're already starting to do the mental health evaluations in the old case, then it might be good to try to jumpstart her on offering her some treatment and counseling in case that's what the issue is. Doesn't make any sense to grab the wheel of a car while you're driving. That's like something might be going on. I don't know.
I was getting her.
No, you have the right to remain silent, ma'am.
Your Honor, I have in my notes that there was a hearing regarding mental health court back in December of 2020.
Okay.
I don't know what the outcome of that hearing was, but it went back on the normal docket with Judge Laurent.
Oh, okay.
So I believe
So they
maybe
thought about it and then
they had a
they
hearing about
put it
mental health
back on a
court.
regular?
Yes, Your Honor.
All
I
right.
don't know if she didn't qualify or didn't want it, or I don't know what happened at that hearing, but it's now back on the normal docket in Division 11.
Ms. Reed, I would caution you not to say anything about the facts of your case. You have the right to remain silent. Do you think you might need some mental health treatment?
Yes, I know so.
Okay. Well, it doesn't hurt. Well, the only thing it could possibly hurt to have you scream would be sometimes it takes several days.
No, when I had got prescribed antidepressants or whatever, but when I was going to trying to do the mental court, they end up changing my attorney throughout all that. So I tried to get in contact with him again, and really barely no contact. I have a lot of proof with that. He barely contacts me, and then they just said they dropped the mental court. I'm not sure why. I did everything I was supposed to do. I talked to the Lakeside person. I was trying to get help. I'm not sure why they dropped it.
So you were trying to get treatment, but something kind of.
Yeah, they only just gave me the meds and just stopped talking to me. And I work also, so it's kind of hard for me to try to keep on track with when they text me. But every time I try to check my email, there's never a reply, or they reply when they want to, or the date of, or
With your public defender or with the Lakeside?
Would they change my attorney? I guess with my new attorney or whoever I'm supposed to be talking to with the case.
All right. Well,
I have
here,
evidence of that.
I can give you a bond, but if I authorize mental health pretrial release, it might take a while to screen you. And so, but it might provide you with services if you want them, if you're willing to take longer to be screened. Could we put where if she bonds out anyway, then she doesn't have to stay for the screening?
No, Your Honor, if now they have been stating that if you want her to be screened for mental health PTR, that's going to supersede the bond first.
Oh,
She's going to have to go through that screening before she can bond.
all right, well. All right, if you're working anyway, you probably just want to do straight bond.
I believe Ms. Reed wants to bond out on those conditions, Your Honor.
All right, so could you clarify with me, anybody tell me whether the old case has 3 charges or, it still has 3 charges on it, right?
Your Honor, it came in as 2. It came in as Bat Leo and resisting without. We filed Bat Leo, resisting without, and Bat DV. So it came in as 2, we filed 3.
And we have 1 bond, which is count 2.
They have a 1,500 on count 2?
Yes, the other 2 are PPR, I'm assuming.
Oh,
What do you have?
Yeah, it's PTR for the BAT LEO resisting without, 1,500 on the battery DV.
okay, get it, all right. All right, well, let's make her post 2,000 instead of 1,500.
On the add-on bond?
Yeah,
2 is 2,000?
no. Let me continue PTR on count 1 and 2. On the battery, we'll revoke the 1,500 and make it 2,000. So, I mean, she's having to go through the process and up in the bond a little bit.
We have battery as count 2.
Well, whatever battery is, whatever the bond is, we'll just up it to 2,000 to give it some sort of impact. Because it's a violation of your release conditions to get a new charge while you're out on bond, and you're heavily at risk of being no bonded. And I'm not doing that.
So, Your Honor, because it's all under one case, are you revoking the case, but keeping PTR on counts 1 and 3, and then revoking the bond on count 2 and making it 2,000?
Yes. Is that a problem?
I guess it's okay.
All I'm trying to do is accommodate the normal expectation that something happens and her bond gets hiked a bit. I'm not wanting to double it. I'm not wanting to revoke her because I think she probably needs some counseling, maybe a little medication based upon what I've seen. I'm not trying to keep her in. She says she works. So what is it that you need? Because this is obviously a confusing request on the judge's part.
I guess I'm trying to see how that's going to be done. The PTR.
Take no action on the PTR.
So on that, she's gonna put no action, and on here, I'm gonna put count 1, PPR, count 2, 2,000, count 3, PPR.
Okay.
Okay. And then the new charge?
The new charge is the $1,000 bond, no contact with the victim, separate residence. If you have the same residence, I couldn't remember that, but if you do, we'll provide a police escort for you to get some things out of the residence while you wait for the next court hearing to see, if somebody's going to testify that it's safe to have contact. Don't have any guns, knives, or weapons. Those go in the care and custody of the arresting officer within 24 hours of your release. You're not allowed to have weapons while you're out on bond for a domestic battery charge.
What do you need her to put on that order if she's taking no action? Because I'm not sure about that order.
No action.
No, that's not.
Ma'am, don't make me sorry. I'm not trying to make it easy. I'm just trying to be careful and try to be proportional with what I think you need. All right, thank you. Okay. Is this Mr. Sosa?
Yes.
Thank you, sir. We have case number 2021-CF6112. I'm not seeing a public defender form, but we generally recommend that you get appointed the public defender at the moment, even if you're thinking about getting a private attorney, because that way we can get the paperwork started, and it's going to Division 22. If you want the public defender, go ahead and fill out one of those forms, and it does help the process.
Okay, okay.
We have sufficient information in the police report to call it an aggravated battery, because when the person is pregnant, then it becomes an aggravated battery instead of a regular battery, and it becomes a felony instead of a misdemeanor. I understand that you might have been the one that called and you were worried about the Baker Act situation, and then when the police talked to both persons, they arrested you instead of checking her out for Baker Act. And your history is not extreme. We'll take that into consideration. When she's not here to testify that it's safe to have contact, we have to order no contact, separate residence, police escort to get some things out of the residence if you need that in order to comply with the no contact order. And this order persists. She doesn't have the ability to change it or let you have contact without you going back to court to see about a judge hearing from both sides, where she actually shows up and convinces the judge that it's safe enough to have contact, okay? If you want that hearing, talk to the public defender or whatever other attorney you're planning to get to try to get a hearing set right away. Also, you're not allowed to have any weapons while you're out on bond for a case like this, so we'd require that you put any guns, knives, or weapons in the care of the arresting agency within 24 hours of release. Given that it's technically a felony at this time, sir, I'll go with the $1,500 bond on this.
Thank you, miss.
You're welcome. Make sure you make all your court dates. Is this Mr. Taylor?
Yes, ma'am.
Okay, sir. We have case number 2020-CF244680. It's in Division 19, and I'm assuming the public defender was previously appointed on this?
Yes.
Okay, thanks. And basically, it's a failure to appear warrant on an ag battery on a pregnant person and false imprisonment. Allegedly, you had a hearing on March 16th and were not there. So Judge Roche revoked your bond and put you at no bond, and so, which happens a lot when you fail to appear. And I generally don't touch the bonds that were set by the trial judge. You may want to talk to your lawyer about what kind of good notice you got or didn't get. Just
Say
for
one thing.
future reference, I want you to know that your court paperwork is available to you online, public record through the clerk's office, so you can keep up in the future with your court dates by looking up Orange County Clerk of Court records and inputting your name, okay?
Yes, ma'am.
You want to
say
tell
one
your
thing?
lawyer what happened, and, supposedly they didn't give you good notice and it was their fault that you failed to appear, and then maybe they can email their trial partner in that division and ask him to set you a hearing.
Okay.
Okay. So, Mr. Taylor, I'm not going to touch Judge Roche's bond. You're going to go have to talk to her about it. All right? Okay. Good luck. Okay. Thank you. All right, is this Mr. Corey Dixon? All right, sir, thank you. This is case number 2002-1MM3515AO. We can appoint the public defender to represent you. They had enough information to at least file the charge of domestic battery. And we don't have a witness here, so we'll be telling you no contact until you can get back in front of a judge, and both parties can be heard to testify that it's safe. And so if you need a police escort to get out some clothing and personal effects to use while you're waiting for the next court hearing, we can give you a police escort to get some things. If you have any guns, knives, or weapons, put those in the care custody of the arresting agency within 24 hours of your release. We have a little concern, although you don't have as much history, and technically you qualify for pretrial release, there were alleged threats to kill, and allegedly you do have a gun. The threats to kill were, I guess, in regard to the neighbor that you might think is cheating with the girlfriend. But I'm a little concerned about that.
Your Honor, I believe there were other threats to kill. He claimed that he was going to shoot up her house and drive through her window to hurt her. The victim on scene, according to the officer, was crying, continuously looking around the vicinity in fear of Mr. Dixon returning. State would object to PTR. I understand he otherwise qualifies given the charge. However, he does have a history, and given the facts in this case, state would object. If you are otherwise inclined to still place him on PTR, I would ask for bond in conjunction with PTR.
Your Honor, if those phrases were spoken, they weren't sufficient enough for a charge from the state. He does qualify for PTR after being interviewed. He has been employed full-time for the last 3 years. I would have you consider that in your determination as well, Your Honor.
Your Honor, just because the officer didn't file them did not mean they're not sufficient for the state.
So, exactly, I understand that. I was concerned enough to think that drugs or alcohol might be involved.
There was an allegation of drinking, Your Honor, in the affidavit.
And so, and in fact, that might have been a very primary cause because he was acting somewhat out of control. So if I grant PTR, let's also add random urinalysis and breath alcohol testing to confirm that you're not doing any drugs or alcohol. And I think it's sufficient to say you should not only just stay away from her until a judge can assess that it's safe, but also the neighbor that you supposedly are afraid is cheating with her. You can't take matters in your own hands, ma'am. Sir, if she's cheating, then just leave her and find a woman who won't cheat. If your brain is running away from you because you've been drinking or something, that's a separate problem, but I want to get that one under control by telling you to stay sober while your case is pending. The alternative is to hike the bond up because we're concerned about the threats to kill. But if you can stay off of the sauce, maybe we're okay while the case is pending. No, cheating hurts, but the real answer is to leave her, not to kill the guy. Now, that's stupid. You just stay in jail for the rest of your life if you do that. Just leave her, that's all. If it's really happening.
That was straight pretrial release to RUA.
With RUA and breath alcohol testing, because with threats to kill, I want him to stay sober, period. If they catch you getting high, you'll have to come back here and see about whether you should post a bond. I'm not otherwise worried about people who stay in their house and get high, but if you start threatening to kill people, I get worried. All right, good luck.
So, Your Honor, is the next door neighbor considered a witness? No contact with the victim or witnesses?
Well, he's a potential victim. You could, I don't care what you call him.
I wrote neighbor.
Neighbor, because I think if you read the police report, they'll know why. He thinks she's been creeping over to the neighbor's house.
Sir, do you want me to check on do not consume alcohol or legal?
Yeah, and that's why he's can be tested. All right. Is this Mr. Morrison?
Mental health, Your Honor.
Okay. Y'all want to do that one anyway, or put it to the side?
Your Honor, we can go ahead and do it.
All right, it's case number 21MM3550. Let's go ahead and appoint the public defender. We don't have a public defender form, but the mental health issue.
We'll waive the appearance, Your Honor.
Okay, I was willing to find a probable cause for battery, resisting without, and threat to Leo. And I don't know that I was aware of mental health, although intox was an issue, I think. And we would find probable cause on the battery, order no contact with the victim. And follow any requirements by Department of Children and Family Services in regard to contact with the 11-year-old child. In regard to the domestic battery, I guess that's a $100 bond. The resisting is a $100 bond. Threat to law enforcement.
In regards to the bond on the Bat DV, there was a 2021 felony Bat DV and aggravated battery on the motor vehicle and aggravated assault with a motor vehicle that the defendant just picked up April 13th of 2021. The victim was the same victim.
Okay. I was going to put the $1,000 bond on the threat to the law enforcement officer because to me, that was pretty serious. So that, to me, was the higher bond, not to minimize the battery. It was going to be $1,000 plus pretrial release with a requirement of no alcohol or drugs, random urinalysis, and breath testing as appropriate. It might be a mental health issue, but it's also fueled by some other things.
Your Honor, are you ordering separate residences, one-time return, and no weapons?
I think I ordered this separate residence, but I'll order a one-time return and also that any weapons have to be put into the custody of law enforcement within 24 hours of release. Thank you.
Okay, so is bond for pre-trial release all 3 counts or just count 3?
All 3 counts is fine.
Paperwork-wise, all 3 counts is a whole lot easier,
Yeah.
Your Honor.
All right. And if it is a mental health issue, just let us know and I'll sign that order instead, counsel. All right, is this Mr. Martin? Thank you for waiting, sir. This is case number 21MM3547. And we can, let's see here, We can appoint the public defender to represent you based upon your paperwork. If the other person is not here, then we are going to order no contact, separate residence, while you're out on bond, until a judge can hear from both parties. I understand you were both here on vacation, and that creates a complication, but you now have a criminal charge pending, and you'll have to deal with the court dates on that until the case is over with. And I think you also live together in New York. I don't think I have the authority to authorize a police escort to get some things out of the residence in New York. So you may want to, in order to, you would violate release conditions if you're together up there. Whether or not anybody finds out and extradites you is another question, but it does result in revoking of your release conditions if you are found to be violating your release conditions to have no contact. So I'd recommend if you need to get some third party to help you get some things out of the residence, that might be a good idea. No, thanks. If you have any guns, knives, and weapons with you here in Orlando, give those to the custody of the arresting agency within 24 hours of your release. And we don't have any indication that you qualify for pretrial release because of prior criminal history, including criminal possession of weapons, including firearm, assault with intent to cause serious injury, reckless endangerment, things like that. So generally, I protect the bondsman, and I'll give you a bond, but it'll be $2,000 because if the bondsman has to get on a plane to bring you back here, that is a financial protection for the bondsman in that regard.
Your Honor, there was also an allegation of drinking. State would ask for no drugs or alcohol without a valid prescription.
All right, no drugs or alcohol while out on bond without a prescription. Thank you. Okay, Ms. Miller, this is case number 21MM3543. It looks like we have a witness. Let's appoint the Public Defender's Office to represent you. Sir, could you raise your right hand to be sworn in to tell the truth? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can put your hand down. State wants to ask you some questions about safety.
Good morning, sir. Can you please state your name for the record?
Dante.
I'm sorry, I can barely hear you.
Dante Gibson.
Thank you. And what is your relationship to Miss Miller?
We're a couple.
Okay. Approximately how long have you known?
Could you speak up? The judge is old and I'm having a hard time.
We're a couple.
A couple, okay.
And approximately how long have you known her?
9 years.
Okay. And has anything like this ever happened before?
No.
If anything like this ever happened in the future, would you feel comfortable calling 911?
Yes.
Do you want to have contact with Miss Miller?
Yes.
Are you afraid of Miss Miller?
No.
And do you believe drugs or alcohol played a part in this incident?
No.
All right, thank you. That's all I have, Your Honor.
Okay.
No questions, Your Honor.
Did Department of Children and Family Services get notified or not?
I don't know.
Okay.
I don't see any note in the affidavit, Your Honor, which generally means that they did not.
Right.
I believe there was note that
She didn't see any.
the daughter was not present, did not witness it, so.
All right.
I believe Ms. Miller otherwise qualifies for PTR. State has no objection to PTR.
Okay. And no hostile contact?
Yes, Your Honor.
All right, folks, that means, so pretrial release means because of your lack of criminal history, you can get out without posting bond, okay? There are some requirements in regard to pretrial release. Talk to them about it. They probably have a list of requirements. Make sure you make all your court dates. We'll give you the address and phone number of the public defender. You might want to talk to them before your court date so they can be better prepared. No hostile contact means no fighting while the case is going on. If there become any orders from Department of Children and Family Services, follow up with, those are also a condition of this particular case, and they get involved sometimes when there's alleged violence in the home, right?
State would just request no weapons, firearms, or ammunition.
If you
Your Honor.
have any weapons, put those in the custody of the arresting agency within 24 hours of your release for safekeeping while the case is going on. Good luck, ma'am.
Thank you.
Good luck. Mr. Pryor?
Yes.
Okay, sir. The case number is 21MM3535. Thank you. We can appoint the public defender to represent you. They had enough information to file a charge of domestic battery. And you do have some prior history. If your dad's not here, then we're going to order no contact, separate residence, provide a police escort to get some things out of the residence while you're waiting for the next hearing date. We have to say no contact unless both parties are in court and there's testimony that it's safe. So if you want a hearing like that, ask your public defender to set one up, and changes of release conditions can be heard relatively quickly in the Division 50 Domestic Court. And this is all happening while you were out on bond or release. Oh, so it was really, it was released on own recognizance after 33 days. It was revoked because of an alleged failure to appear in January. And then you showed up and the judge ordered PTR instead of ROR at that time. And
Your Honor, that may, if I may.
did that got filed though, right?
Yes, Your Honor. We filed on the dealing and stolen property, the trafficking F2,
Okay,
which comes in with a bond of generally $2,500.
okay.
In the notes in our office, Your Honor, I have that set for pretrial conference, as well as there's a pending plea. So I would have you take that into consideration, not to complicate that, I suppose, with any.
Yeah, so when is he set?
Pretrial conference?
Pretrial's tomorrow, Your Honor.
Tomorrow, no problem. Okay,
In Division 15.
all right.
Your Honor, state would ask that you do revoke and set a higher bond. This case has gone through many different bond conditions or release conditions. And he did commit a new law offense while out on bond, which is a violation of being released in any term. And given that he has a plea offer doesn't set aside that he did violate his release conditions.
Your Honor, he's also been unemployed for 3 months, so a higher monetary bond may be unattainable for Mr. Pryor.
You know, I had to say, I was a little struck by the circumstance of allegedly demanding money from his father when he's 28 years old and then pushing his father down.
His father's also 60 years old, Your Honor, which creates a whole nother potential set of issues regarding injuries.
Everybody knows that those of us over 60 are exceedingly frail.
I didn't mean it in any offense, Your Honor.
I'm just joking. It just kind of shows that there's a problem here. Don't say anything about the facts of the case. You have the right to remain silent, sir, but, when a judge sees things like this, it could impact the judge's decisions. In regard to this battery, I'll go ahead and give you the regular bond of $500, but I'm going to revoke and hike the one that you're out on bond for to the $2,500. You're going back to court tomorrow anyway, no big deal. You'll have to go back, they'll have to transport you over there, and the judge will see probably what happened while you're out on bond. And, sir, I'm not trying to just mess with you. I'm trying to wake you up. Your father doesn't owe you anything.
Your Honor, I'd just like to put on record, his last conviction was 2 months ago, and it was a violation of a DV injunction. The victim in that case was his mother.
You're 28. So we're going to revoke the pretrial release and set the bond at $2,500.
And Your Honor, I'm sorry, I missed the bond on his new law.
So the battery is 500.
All right, thank you.
No contact with victim, separate residence. If you need a police escort to get some things out of the residence, we'll order that. Any guns, knives, and weapons have to be put in the care of the arresting agency within 24 hours of your release on that charge. Nothing but respect. That's the only thing your parents are entitled to from a 28-year-old man. Good luck. Okay, is this Miss Slater?
Yes, ma'am.
All right, ma'am. This is case number 2021-MM3541, and you do qualify for the public defender, ma'am. Another mom and dad and daughter thing, grabbing and pushing, both, I think both of you were maybe accusing each other, but the mom is the one who had some bruises on her back and her biceps, so sometimes when they can only find the injuries on one person, it's the other person who gets arrested, okay? So they had probable cause. You meet the criteria for pretrial release, I think, unless the state objects. I'll let them tell me if they do.
The state has no objection to pre-trial release, Your Honor. There was an independent witness, however, that cooperated the mother's side of the story.
Okay. So pretrial release means you can get out without posting bond and just keep up with the pretrial release office and follow their requirements, okay? Make all your court appearances. We're appointing the public defender to represent you. If you have any guns, knives, or weapons, put those in the care of the arresting agency within 24 hours of your release. At the moment, because we don't have any testimony from your mother, we're going to need to order no contact separate residence until you get back into court and she testifies about whether it's safe. And so if you need to get a police escort to get some things out of the residence, a police escort can be provided for that. And talk to your lawyer if you want to have a hearing on that release conditions. Good luck, ma'am. Oh. Yeah, is there a line? Oh, 2,500 is down here. Okay. Thank you. Okay. And is this Mr. Fedorchak? Thank you, sir. A couple things here. As far as 2002 1CT 3592, that is a failure to appear warrant. We can appoint the public defender at anything that he already doesn't have a public defender on.
Your Honor, yes, the 21 CT 3592, on the failure to appear warrant page, it says it's Ulysse. In my system, as well as in the clerk system, it's actually no valid. State did convey an offer of a withhold and credit time served.
Okay.
Your Honor, I did have a chance to speak with Mr. Fedorchak on that offer. We're a little concerned because he says he can't get his driver's license, which may help him downtown. But concerning the out-on-bond cases, we're concerned that if he doesn't take that plea offer on the no valid driver's license, that the bond would be revoked and set at none on his out-on-bond cases, we would argue. Against that, if necessary, set a higher monetary bond. But if the Mr. Fedorchak does take the offer from the state, would you consider no action on the out-on-bond cases?
I'm not extremely worried about the out-on-bond cases anyway, because he's basically been put in jail for failure to appear for arraignment. He's, I looked at the license and I actually was having trouble telling whether he just had exam problems or an FR suspension, but he didn't have a whole slew of suspensions.
And Mr. Fedorchak has said he will go get his driver's license as soon as possible. I've spoken with him about it.
All right, so does he just want to postpone and not take no action on the other ones?
Yes, I believe he would prefer that, Your Honor.
All right, that's not a problem. And I know it gets a little confusing when you have a bunch of cases pending, but you might want to reconsider whatever decisions that you might have made in the past that might be causing some of these cases to happen. Because life could be more simple than having a bunch of cases pending at one time.
Your Honor, so you're saying the bond at 2,000?
Yeah, but I'm not going to do anything to the other ones, and so if you get out, just
Thank you.
try to settle your license and get it straight and see if they give you a break on that. They might. All right, good luck. Is this Mr. Freitas? Sir, thank you. We have case number 2019 CT 1330 and 1331 AA. And that's a failure to appear on a driving while license suspended, bond amount 1,000, and also attaching not, a tag not assigned at bond of 1,000. I think he's got 4 days credit on each.
Yes, Your Honor, state did convey an offer of a withhold credit time served on both.
All right, and the main thing to be concerned about is be careful about getting these driving while license suspended on your license.
Your Honor, we did have an offer from the state. I don't know if she said withhold and credit time served for the two failure to appear charges tagged not assigned and driving while license suspended or revoked. I spoke with Mr. Freitas, about those conditions as well as the repercussions of entering a plea, and I believe he understood and would like to enter a plea today, Your Honor.
Okay. Sir, if you want to resolve it, go ahead and sign the plea form after you've read it. Right. If he takes the plea, I won't appoint the public defender because they generally don't want to charge him the extra $50,
I did
correct?
speak to Mr. Freitas as a friend of the court, Your Honor.
Thank you. All right, thank you. Sir, I basically want to tell you now, I'm a substitute judge, been retired for a few years, but so what I don't know, and I would advise you to be very careful of, is whether or not these withholds of adjudication count against you for the purpose of a 5-year revocation. If you get 3 driving while license suspended within 5 years, you can get a 5-year revocation. The reason I'm not sure about the withhold is because the law has changed back and forth a couple times since I was a lawyer and a judge, and so I don't actually know whether withholds of adjudication will qualify you for a 5-year revocation. But this looks like number 2, at least, and there might be number 3 in the little pile of things that you have not paid so far. And the other problem with these is that, you know, if you just give up and you decide it's too huge and you're not going to do it because it's just too big, you'll never be able to drive. And, you know, that complicates the process of becoming an adult because you can't really work. So you are almost at the point where you have to make a decision that you're going to take a second or third job and dig yourself out of the hole, unless you want to be like one of those guys that rides their bicycle everywhere because he just can't get a car or a, you know. So as I've told you, I don't know whether this counts or not for the purpose of a 5-year revocation. But if you get one of those, it's a real hard thing to get your license back. And do you have any questions about that?
When this occurred, when I got arrested for this, that was the first time I've ever been put in jail for any traffic violation.
All right, so are you telling me that now you're taking it seriously and you're figuring out that it's a crime?
I knew it was a crime at the time, and I knew it was wrong.
Okay,
I don't believe he has any prior Ulysse, Your Honor. I think he's saying he has no prior traffic history.
oh, well, maybe the one I'm seeing on his
You're looking
record
at
is this
the-
one.
you're
Oh, that's
looking at
what
the
it is.
arrest, Your Honor.
And it's suspending him. Okay, well, maybe this is the first.
I believe it is his first. I checked his CCIS.
All right, and it's a crime, you understand that also, because you're kind of young. And you'd rather take the credit for time served and withhold and get it over with than to bond out and come back to court? Is that, yes, let's say yes out loud so we can get it on the record, okay? So you're 23. Have you understood the rights on your plea form?
Yes.
And those are your rights to see if the public defender can find any technical defects in the state's evidence and test the state's ability to prove it or not beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced that the state proved it. Do you understand that?
Yes.
Are you willing to give up all those rights in order to finish your case today? Because the alternative, I think, is call your parents to bond you out and see if you can't get your license back before you come back to court. So the quickest thing is to plea out. The less quick thing is to call your parents to bond you out, maybe they would, and then make sure you try to get your license back so you can,
I would like to plea out.
you'd like to plea out. Okay,
He has told me he's going to attempt to get his license back as soon as possible as well, Your Honor.
all right. Sir, it appears that you know what you're doing, that you're alert, intelligent, entering a plea of no contest in free and voluntary manner. There's a factual basis. We'll accept your plea, withhold adjudication on both charges, the driving license suspended, 19 CT 1331 AA, and the attaching tag not assigned, or I think?
Yes, Your Honor.
Okay. 19 CT 1330 AA. Those are 2 small crimes. They're withholds of adjudication. You need to understand that. I guess they each are going to carry their own set of court costs, which is expensive for a 23-year-old. I'll give you a year to work on that, but I think it's about $600. You can make partial payments at the clerk's office. I think they even accept payments online. All right? And you have credit for 4 days' time served. We're going to release you as to these charges. Good luck, sir. The clerk's office might assist you figuring out where your suspensions are. Did you talk to him about that? I wonder if he even knows where to go to get figure out about his suspensions.
I believe he said he was going, I asked if he was going to get his license. He said yes. He didn't ask where to do that.
Yeah, that's part of the problem is
The
people
DMV.
just get confused. All right, so the next
understand
person, Mr. Marcial Crespo, bonded out. But we have thank you, a Chloe Putman. And, thank you. I think she has Mr. Hyman for the old DUI, and she just got a new DUI. Case number 21 CT 465 AA. And,
Yeah, Yes, Your Honor, there's no offer at this time due to being a DUI.
Right. She filled out a public defender form, so, ma'am, what we could do, and she's 22, so I'm just guessing that her parents might have been getting the attorney the last time. And she's out on PTR for the old DUI. Probably Mr. Hyman knows that we're going to make you post bond to get out on the old one that you're out on PTR for. And we'll find probable cause in regard to the new one.
Your Honor, state asks that you appoint a PD until Mr. Hyman can file an NOA.
I'm doing that. I think that's what I mentioned. I'm just looking at the bonds. She doesn't have other history, but and her license, I guess, was valid, so it wasn't like she was driving on a DUI suspension.
Your Honor, she's also a student, which monetarily speaking, maybe any monetary bond may be unattainable.
I'm just assuming her parents are dealing with it until they, start doing the tough love thing, maybe.
Your Honor, I ask that you stay her new law and revoke and set double for out on bond. These are particularly
Right.
dangerous, at least for the community.
Stay the new bond, the new law at, they have her at 1,000. Is that because of the blood alcohol level? Are we doing 1,000 now on those?
It's because she blew over a .15.
Right, okay. That's new for me. So, but if that's normal, I'll go ahead and leave that at 1,000. And in regard to pretrial release, revoke and put it at 2,000. I'm pretty sure Mr. Hyman is used to that. That would be entirely normal.
Your Honor, I believe the bond amount on the out on bond case was 500 along with PTR.
No, it was just PTR. I don't know why they put the bond amount on there, but she was just out on PTR.
Thank you.
But I think he's trying to say the standard bond for that charge was 500. So you want to make it 1,000?
Well,
I guess my argument.
no, I was going with 2 because it's a violation of release conditions to get a new DUI. And I think 2,000 is completely normal. Now, I know you guys are doing things a little different with a lot of concerns by the newly elected state attorney and everything, and who campaigned on, being against cash bail and everything. Number one, I'm used to there being a revocation in something like around 2,000 on a DUI, because if you get another DUI.
Your Honor, I believe the 2,000 is reasonable, given they're both from 2021. They're about 3 months apart.
Yeah, and the reason I'm mentioning the new state attorney is that there's been a lot of discussion about cash bail and people being in jail and all that kind of stuff, and I understand that, but it's serious to get a new DUI when you're out on bond for a DUI. It's a public health problem as well as a danger to yourself, ma'am, and I don't think that Stuart Hyman's going to be shocked at all about that. I understand the public defender's trying to, help you, but that's just where I think you're at. I think you're at 2,000 and 1,000. Unfortunately, you're going to have to call your parents maybe about it. And, but, good luck with that.
Your Honor, state would ask for the condition of no drugs or alcohol without a valid prescription on her new law.
And she asked that on all the cases involving drugs or alcohol. She asked for me to order no drugs or alcohol while you're out on bond. I realize we can't run around and watch everything you do, but if you get caught, it's a violation of release conditions on everything else. All right, good luck. Okay, the regular misdemeanors.
Are we going into pleables or are we going into arraignment?
They've got pleables first.
Okay.
Is this Ms. Bates? All right, ma'am.
Yes.
We have a new misdemeanor called resisting an officer in case number 2021MM317AW. And we can appoint the public defender to represent you, ma'am. You're also on bond or released on unrecognizance on a burglary of an occupied structure in 21 CF 3844AO. As far as I could tell, that one hadn't been filed yet. But the other one that you're out on bond for is 2020 CF 12957, and that case has conflict counsel. I didn't look into the details of why you have conflict counsel, but that means eventually you'll get conflict counsel on this one too, unless you resolve it.
Your
Honor,
Honor,
state did convey an offer of an adjudication credit time served. If she takes the offer, state recommends no action on her out on bonds.
I would concur with that, Your Honor.
Sounds like a pretty good deal for Ms. Bates, given the fact that she keeps getting arrested. One of the things I noticed was that the police officers know you now, and so do the various places that you visit. So, when they get called out, the people say, oh, she lives over there, kind of stuff. So they may or may not appreciate it if we let you right back out, but at least they know who you are and where you are. And, it's more of a nuisance situation for them that you're homeless.
May I say something, Your Honor? I just want to say
You
one thing.
can, you have the right to remain silent, but, I mean, they're offering you time served. I don't think you're going to talk yourself into something worse, but you might want to check with your lawyer first.
On my other cases, helping me to go to treatment facilities and stuff and try to do better.
Yeah, well, you want to do that because living on the streets, what the other people look like. You haven't aged too much yet, but you know what I'm saying.
Yes, ma'am.
It'll age you really fast.
Yes, ma'am.
Because I watch it. I've sat here for years and watched people just age right before my eyes. All right, so that'll be up to you. I'm happy to go along with time served. You look like you're still pretty healthy. I hope you can, turn it around.
Yes, ma'am.
Okay,
Thank you.
you're welcome.
And if I was not appointed to this case, Your Honor, I did speak with Ms. Bates as a friend of the court.
Okay, he doesn't want to charge the PD fee. Thank you. You're welcome. Ms. Bates, I need to get you sworn in and ask you a few questions. Would you raise your right hand? Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. So, Ms. Bates, did you see this plea form well enough to know what's on it?
Yes, ma'am.
All right. These are legal rights that you give up when you plead no contest. It means you won't be presumed innocent anymore. The state won't have to prove it beyond a reasonable doubt to a jury of 6 people, all of whom would have to be unanimous that the state proved every aspect of the charge before you could be found guilty. Do you understand that? And so nobody will be arguing about technical defenses to the state's evidence or say anything on your behalf. You'll just be accepting a conviction, and the case will be finished without them having to prove it. Do you understand that?
Yes, ma'am.
If you had been on probation, this would violate your probation, and if you're not an American citizen, this could result in deportation. Any questions about that?
No, ma'am.
All right. It appears that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. It appears that you're sober. There's a factual basis. We'll accept a plea of no contest. Now, I don't know if you got a little bit of convictions already, so this, be careful, these convictions add up for the points of sentencing guidelines, and also make it difficult sometimes to get jobs, so be careful
Ma'am.
about collecting them. But we'll adjudicate you guilty on resisting, sentence you to the, is it 2 days? Time served, release you as to this charge. We always, as you probably know, impose the court costs, they're around 300 and something, but we'll give you a year to try to work on that. You can make partial payments once you get on your feet, and we don't rearrest you for not paying, but we never let you have your license back until you dig yourself out from all these fines. In the meantime, we'll take no action on the other ones that you're out on. Wish you good luck. Okay. Okay, is this Mr. Dormady?
Yes, Your Honor.
All right, thank you, sir. So this is case number 21MM3542. I don't have a public defender form, but just let us know if you need a public defender. It's generally going to Division 81. And it looks like they have enough information to at least file it, regard to a couple grocery items.
Your Honor, there is no offer on this one as it is enhanceable. State, we just ask that you stay the bond and do a condition of no return to the target.
All right, sir, it does get to the point and where even a small case like this could be enhanceable. And I understand what the state's asking about. So I'm inclined to go ahead and just set the bond at the $500. Did you want the public defender?
Yes, ma'am.
Okay. I'm not seeing a form. Maybe you filled one out. If
I can't make bond.
I get it. With your history, there's a possibility that they could upgrade this, and that's why the state wants more time. And also with your history, I would not be inclined really to lower it. I think you get to the point where you're kind of getting stuck as a result of history and decisions that you might have made in the past. So I think you might be at that point. I'll appoint the public defender and recommend that if they hand you a form, it's better if you fill it out. And that's all I have for you at the moment.
Your Honor, he does have reporting requirements.
Oh, sir, you've got some reporting requirements. Do you understand what I'm talking about?
Yes,
You have to report every arrest.
Yes, ma'am.
All right, good luck to you, sir. Is this Mr. Harvin Pierre?
Bonded, Your Honor.
Thank you. Is this Mr. Hinkle?
Yes, ma'am.
All right, sir. Sir, we have case number 2021-MM3530. I don't have a public defender form, but if you need their services, just ask and we'll give you a form to fill out. It's going to Division 82. The allegation is trespass. Looks like they've got enough information to at least file it.
Your Honor, state can make an offer of an adjudication, credit time served, and no return to the Wawa.
And Your Honor, I did have a chance to speak with Mr. Hinkle about the terms of that offer as well as the repercussions of entering a plea, and I believe he understands the rights waived and that he would still like to enter a plea today.
Okay. All right, sir. If you wish to enter a plea, then make sure that you have looked at the plea form and that you understand that you're giving up the rights listed on the plea form. And once you've made that decision, go ahead and sign it.
And I did speak to Mr. Hinkle as a friend of the court, Your Honor.
Okay, thank you. Thank you very much. Sir, would you raise your right hand to be sworn in to answer some questions? Do you swear to tell the truth, the whole truth, and nothing but the truth? All right, you can put your hand down. I would need for you to speak up a little bit because we have to get your answers recorded. And, sir, you would be giving up the rights listed on your plea form if you accept the charge today. You won't have a trial, you won't have a defense, nobody will have to prove beyond a reasonable doubt that you were trespassing at the Wawa, and nobody will file any objections to the state's evidence or technical defects or defenses on your behalf. The state won't have to prove it beyond a reasonable doubt to a jury of 6 people, all of whom would have to be convinced that the state proved it. Do you understand those sorts of rights?
Yes, ma'am.
And are you willing to give up those rights in order to finish your case today?
Yes, ma'am.
And if you were on probation, this would violate your probation. If you're not an American citizen, this would potentially result in deportation. Do you understand this?
Yes, ma'am.
Okay. Sir, it appears that you are alert, intelligent, evidently sober, entering a plea of no contest in a free and voluntary manner. There's a factual basis to accept your plea. I'll accept your plea of no contest, find adjudicate you guilty of the charge of trespass, sentence you to the credit for probably 2 days' time served, release you as to this charge, tell you not to return to the Wawa. They have a trespass warning anyway. And we do always impose these court costs, which are $300 and something, and we'll give you a year to pay. We don't arrest you for failure to pay, but we do revoke, we suspend your license every time you don't pay your fines. So if you ever do want to get on your feet and get a license, you'll have to deal with these fines, and you can make partial payments at the clerk's office or online. Good luck. Okay.
Ricardo is mental health.
Okay. Should we look at that one? It's 2002-1MM 3517, and appoint the public defender. It's in Division 85.
Your Honor, we'll waive the appearance. There is an offer from the state of adjudication of guilt, credit time served, no return to Publix. Would you be inclined to reset this till tomorrow if she feels better?
Yeah, I don't mind.
It's mental health.
I know. Is that long? Okay. Scratch that. We will waive the appearance, Your Honor.
Okay. I guess we can stay the bond at the 500 on that. And
She would ask for a no return to Publix.
Don't return to Publix. Do we need to do something on the burglary conveyance, or? No.
There is an out on bond, Your Honor.
All right, she's got convictions for theft and disorderly and other things. All right, well, then, oh, she was out on the ROR on the burglary. Did the state ever file that?
Yes, Your Honor. It came in as the burglary conveyance, attempted burglary conveyance, and a petty theft. She was ROR due to a 33-day motion.
Right.
She's since filed with the burglary conveyance.
Okay, so it's only count 1 and not count 2 and 3?
Yes, Your Honor.
All right.
Your Honor, we would request no action. She's already here.
She's what?
She's already in confinement. She probably will be for some time, so I would have you had no action on that.
Your Honor, that is due to picking up a new law offense, which is a violation of
She's
her
got a
animal
bit of a
conditions.
history, counsel. I'd be inclined to go ahead and give her some more credit for time served on the burglary. It might actually help her resolve it. Let's revoke the ROR and set bond at just $2,000. She's obviously on the ropes. She's not getting out anyway. Is there a detainer for mental health?
Yes, Your Honor.
All right, in that case, basically would recommend that you give a note to your lawyers in the trial division to get the evaluation started sooner than later.
Yes,
Thanks.
ma'am.
Okay.
I'll email them today.
Yeah, let's go ahead and appoint the public defender if they haven't already. She's been in for 33 days, so I think she probably got the public defender. All right. And then what about Miss Murillo? Okay, thank you. That's case number 21MM 3548. Division 63.
May we be appointed, Your Honor?
Let me just look at it for a second. Okay, and they have enough probable cause for the battery and petty theft. Let's go ahead and appoint the public defender.
We'll waive the appearance, Your Honor.
Yes, sir.
I do have concerns as well here, so perhaps the same situation as the previous case.
She doesn't have as much of a criminal history, but she's got petty thefts and
Batteries.
He's out on bond on a battery on a firefighter case, Your Honor.
battery and a little bit of drug history.
Your Honor, in regards to her out on bond, the bat on a firefighter, state would ask that you take no action. It's not filed on yet.
Oh, thank you for that. All right, so we'll take no action on 2002-1 CF 5703. Her history isn't quite as bad as the other ones, so we'll just set bond at 500 on the battery and 100 on the petty theft. And I don't know that she's eligible for mental health pretrial release because of the types of charges. No.
You can have her screened, Your Honor.
Well, okay. Or mental health pretrial release if eligible. It sounds like it might be time to start checking that out.
Your Honor, state would ask for no return to the Circle K and no contact with any of the victims or witnesses.
So ordered, thank you. Okay, is this Mr. Alston, who's been waiting for a while? Thank you, sir. Sir, we have 2002-1 MM 2606 and 2002-1 MM 3513. In regard to 2606, evidently was a failure to appear for arraignment on the 20th of May on a trespass charge, and the bond was set at 500 on that. In regard to 2002 1MM 3513, bond was set at 500 on a petty theft. Wait a minute. I'm sorry. That's a new charge. Are you all thinking about resolving anything? He does qualify for the public defender.
Yes, Your Honor, state conveyed an offer on the 21MM 2606 trespass case of an adjudication credit time served. No return to Kim Thon Plaza, which is 1216 East Colonial Drive. But there is no offer on the petty theft 21MM 3513.
Okay,
Your Honor, I did have a chance to speak with Mr. Alston about the terms of that offer from the state on the trespass in 21MM 2606. He did understand the terms as well as the repercussions of entering a plea, and I believe he wants to enter a plea today.
you think he wants to resolve that one?
Just the trespass? Yes,
Right.
Your Honor.
Yeah,
Okay.
I would like to resolve it all, or I could get it all in all. Cause he said if it weren't for the warrant, I wouldn't be in here today.
Right, well, they're talking about resolving the one for the warrant. The one with the theft, the state wants to see if they can upgrade it to a felony, because if you get a couple prior theft convictions, then,
I only have one. I only have one.
Your Honor, it's a true victim case, and there's potentially restitution.
oh, okay. If you didn't have much of a record, I might be more inclined to help you out, but but I think your history is speaking to me a little bit.
Yeah, I don't have disorderliness
You got a few.
yeah, and I only have one petty theft. That was from for no, I don't have a petty theft. Matter of fact, I don't have one at all.
Looks like you got at least one conviction of that, and they can upgrade a second one. You got 14 misdemeanors, sir.
Your Honor, my only concern, he's been unemployed for 2 years. A monetary bond may be unattainable for Mr. Alston. So he would just, even if he would plead to the trespass, he would still be here on the petty theft.
I'm not having any problem with that situation. I mean, if he's got
And she isn't gonna,
13 unknown dispositions, 14 misdemeanor convictions, 2 felony convictions. I mean, I don't know what people expect. There comes a point where it's, they might have to be doing some jail time just because it's appropriate. I don't see a problem with that.
And she isn't gonna press charges because she said it won't locked up, and she know that I ain't think it was anybody's bike.
Oh, you have the right to remain silent. Anything you do say could be played back at your trial, sir. And, that is one of those examples of wishful thinking. The thought that it's okay to take a bike just because it's not locked. That's not real. That is the kind of thinking process that happens to people that commit crimes because they convince themselves that it's okay when it's not. It's magical, wishful thinking. It's not real. And it doesn't help. It's not like a judge is going to go for that. The judge just hears you telling me your excuse that you tell yourself to make it okay to do what you know that you shouldn't be doing. And it just doesn't work. Only in your head does it work. And in the head of everybody else in this jail does it work. But remember, that's magical thinking. That's why you're in here. And you are old enough to know better. And until you get it through your head that that doesn't work, you're going to keep coming in here. That's all. I'm okay either way, sir. I understand you're probably situated where you're getting to the point where nobody's going to bond you out, and you might sit there for a little while. But if you want to take care of the trespass, that's fine. If you want to go downtown with it because you're not getting any traction on the theft case, I'm okay with that also. It's whatever you want to do.
He still wants to plea, Your Honor, to the trespass.
All right, on the trespass, if you've read the plea form, sir, go ahead and sign it, and then we'll get you sworn in to resolve that one.
Your Honor, I did speak with Mr. Alston as a friend of the court if we're not appointed.
Thank you.
Hey, excuse me. The charges on the prosecutable if she comes down here and
I
prosecute.
can't hear over
right?
that printer, sir. I tried to read over the table, but I recommend that you either speak up or not talk, because you already probably incriminated yourself on the theft charge, and your lawyer probably don't want you to do that again.
I'm trying to get an understanding of my case. It says on the paper that she was provided with an agency number if she wanted to prosecute. So if she don't prosecute, that means I won't be charged, right?
No, because there's security cameras all over the place, and the state can still call her as a witness, whether or not she cares about it. She can be sent down with a subpoena, and if she's a law-abiding citizen, whether or not she cares about the bicycle thing,
Really?
the state can ask her questions. Was it your bike? And, they can still prove it. And you're,
And the bike was just laying there.
sir, do you want to plead on the trespass or not? I'm about
Yeah,
to
I
just
already signed
leave the
it.
bond where it is and move on.
That's fine. They want to throw the book at me.
All right, well, just leave the bond, and you guys can talk about it later. Public defender's on everything anyway.
Your Honor, state would ask for no contact.
No contact with the alleged victim. Good luck. Right.
And now, the credit time served were how many days?
4 days.
I didn't take a plea. I got tired of talking with him.
Oh, okay. So you're saying the bond on both?
Yeah. He can't even focus on the plea. He's just still, no, Mr. Cordero, let's see. We've got case number, I think it's an add-on charge for you, sir.
It was a failure to appear, Your Honor.
Case number 2020-MM4731AO. It was a So evidently, this was going on for a while. At one point, it was returned to the state to perfect service. Maybe you didn't know about it. It might have been a summons. There came a point where you might have,
Your Honor, it was returned to the state. We set a new arraignment on March 16th and then a new arraignment on March 4th. He failed to appear at that arraignment on March 4th, which he did receive a summons for.
so either you were notified or a judge found probable cause. It does say failure to appear, so that judge was assuming that you were notified in regard to a criminal mischief charge. I think you're in jail anyway on something else.
Yeah, it's a FTA for 2 prior convictions.
For what?
2 prior petty theft convictions.
Oh, okay. So, here's another one. It's a criminal mischief. I didn't look up the facts, although they're public record. If you've got somebody who can look it up online with a case number, they could tell you what the
It's been going on for like 3-4 years now, this same one misdemeanor. I just wanted to see if I could get time served on it, because I bonded out the first time, the second time, and now it's going to be the third.
This is from February of 2020.
You may want to, there's $1,500 bond on it. Now, does the state make offers on the ones they're coming back in on from the failures to appear?
Not at this time, Your Honor, due to being a victim case.
So one of the complications is that they probably have talked to a victim if they got one, but they don't have their notes in the file or something. Let's go ahead and leave it at the 1,500 for now and see what your public defenders can figure out.
Okay.
Good luck to you, sir. Just have. And is this Mr. Darouche? Sir? The case number is 2021MO610. Can you hear me, sir? Yeah, okay. In Division 80, we can appoint the public defender. It's a disorderly conduct charge. Allegedly throwing a garbage can in the garbage, falling out downtown. And supposedly pulling plants out of a planter. So they arrested him, and he's on state probation. Seems to have a lot of criminal mischief charges. Batteries, petty theft, trespass, cocaine.
Your Honor, state just asked that you stay the bond, given he's on probation. It'd be unwise for him to take a plea at this time.
Given what reason?
That he's on probation.
Oh, yeah.
Your Honor, Mr. DeRouche has just started work. He doesn't have anyone to bond him out. A monetary bond may put him back, as well as inform his employer that he's
Been arrested.
been arrested.
Well, what
That
about
might
state
affect his
probation? I don't have an on-view paperwork.
I understand, Your Honor, we had probationary issues with entering a plea, which would have got him out and back to work, but entering a plea would have affected probation status. Therefore, I advised him not to take any plea. That, of course, results in him being stuck with a monetary bond.
You
If
know,
he has
he's
no one-
somewhat between the rock and a hard place. I don't know what would have caused him to start just, pulling out plants and throwing over garbage cans unless, he looks normal now. My first thought when I was reading it is whether he's bipolar or not, but he looks like he's okay now, and he's got a bit of history, so
A
I
string
just
of
have
bad
to-
luck can be aggravating, Your Honor.
I'm not asking him to say anything.
I just have to put on record that he did just get a immigration detainer for immigration proceedings. So I don't know if that will affect his decision to plead.
All right, well, yeah, he's already got a history. Sir, let's leave it at, what is it, 250? 250, appoint the public defender. You're going to have problems with your probation case anyway. They're probably going to, there's probably another judge in the building. They've already probably getting them to sign a warrant to detain you on the violation of probation. And there does come a point where, you're just stuck for a while, especially in regard to the violation of probation. Now an immigration hold, so.
I don't.
See if the public defender can help you. All right, are these arraignments? Okay. Okay, the first one we have, I think, is Mr. Adams. Okay. Public defender was previously appointed. I guess we're waiving arraignment then.
We'll waive appearance and enter a plea of not guilty, Your Honor.
Division 82, pretrial conference, July 12th at 10:30, courtroom 10B.
Thank you. Tobias Watts. 2021 CT 3485. Public defender's been appointed.
We'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 83, pretrial conference, July 6th at 10:30, courtroom 6B.
Thank you. Kiara Denise Wilkerson. Case number 2021 CT 475AE. Public defender previously appointed.
We'll waive the appearance, Your Honor, and enter a plea of not guilty.
Division 62, pretrial conference, June 14th at 9 o'clock, courtroom 9B.
Also, she has 2021 CT 476.
We'll waive the appearance on that as well, Your Honor, and enter a plea of not guilty.
All right.
Division 63, pretrial conference, June 10th at 1 o'clock, courtroom 12C.
We have Cesar Arevalo. 2020 MM 8178. That's a violation of probation on a battery. Public defender has been appointed.
We'll waive the appearance, Your Honor, and enter a plea of not guilty.
Denial.
All right. I'll
Entering
enter
a denial.
VOP status, June 21st at 9 o'clock, courtroom 7C.
Jason King. 2021 MM 2485. Public defender previously appointed.
We'll waive the appearance, Your Honor, and enter a plea of not guilty.
Division 84, pretrial conference, June 14th at 9 o'clock, courtroom 4B.
James Neesmith. Thank you. 2021 MM 2201. It looks like public defender's been appointed, I think.
Yes, sir.
Okay.
We'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 81, pretrial conference, July 2nd at 8:30, courtroom 4E.
Emmanuel Strickland,
He's right here, Your Honor.
thank you.
Hello.
I don't know what's going on with all these people in medical. Sir, this is case number 2002-1MM2769. You previously been appointed the public defender and have spent 32 days in on a criminal mischief charge.
There is no offer at this time, Your Honor.
We'll enter a plea of not guilty, Your Honor.
Division 81, pretrial conference.
Just a moment, Your Honor.
Please.
Sure, okay.
Your Honor, I spoke with Mr. Strickland. Although there's no offer from the state, he would like to plead to the bench.
Your Honor, the reason there's no offer this time is this is a true victim case. The victim has a right to be heard under Marcy's law, and there is restitution. I did not know that restitution amount at this time. The ASA has reached out to the victim. The victim is trying to get the damages repaired to get us an estimate so we can have that restitution amount. That is why there is no offer at this time. It is a true victim, and playing them out would violate Marcy.
You know, what I used to do on those, if the person wanted to plea, instead of keeping them in jail over a restitution issue, would be,
Ordering and reserving, Your Honor, becomes a huge issue. Generally, it's 60 days. Sometimes the victim can't get the restitution amount by that time. And even so, she still has a right to be heard regarding a plea offer. An offer has not been conveyed to her or spoken to her about, and there was damage to her property. So she does have a right to be heard and to consult the court regarding that offer.
she definitely has a reasonable right to be heard, and she certainly has the opportunity to talk to the state attorney's office about it and convey her preferences. I've always been concerned about why that communication is not clearly indicated in the file so that it can be brought to the attention of the parties in the court. I don't know what his criminal history is, counsel. That's another thing about these arraignments, is that we seem to be rolling through them. If we ever get to post-COVID or pre-COVID types of procedures, you know, there might be more information available. There might be 2 judges working on these files in 2 different courtrooms and spend, you know, more time on them with more information available, more people notified, more people brought in. But, you know, I've never been persuaded that I should keep a person in jail so that the state can find out how much the restitution is. I'm happy to give the state 90 days to figure out what the amount of the restitution is, but I don't see any reason to keep a person in jail for that. And certainly the state, within 32 days, has talked to the victim and just evidently not found out what their recommendations are.
Your Honor,
But for the public defender, I don't have any criminal history in front of me either.
I understand, Your Honor. And I understand the concerns of the state as well, and I'm speaking for Mr. Strickland on his behalf, and he does wish to atone, so I would have you consider that. But I understand your position, Your Honor.
I mean, I would be tempted to accept a plea. The problem is I don't have any criminal history at the moment, unless the state, you know, wants to say something about that. I understand she's a true victim. I understand she has the right, and she has the right to talk to the state. She has the right to be here. But, you know, if the state didn't get any information from her or tell her that the arraignment's going to come up, you know, that doesn't mean she didn't have a reasonable opportunity.
Your Honor, victims don't come to in-jail arraignment. They only come if they're interested into arraignment downtown. We generally don't convey offers at all on victim cases at arraignment due to it being so close to when it's filed. This case was just filed 10 days ago. That is when the victim was consulted regarding a restitution amount to determine if this is an M1 or an M2 or an F3. It wasn't the time to talk to her about an offer. It was the time to talk to her about if she wanted to proceed and what that restitution amount was.
Well, that's a decision that the state makes, whether they're going to talk to people before arraignment or not. I've never understood why some lawyers do and some don't. I will tell you this, the ones that I've had over the 22 years that I was a county court judge who did that kind of homework before arraignment and then graduated from the state attorney's office do extremely well in private practice because they know how to economize time, save court procedures, and get things done. I don't understand the state's insistence that they don't talk to witnesses a lot of the time before arraignment. I think it's just because they don't want to do the work.
Okay.
I'm sorry. I don't see any reason to keep a man in jail just because the state hasn't talked to their witness.
He has a bond, Your Honor. He's able to leave if he would
If he
like
was
to.
able to bond out, he would have bonded out within the past 32 days. All right, so originally he came in. He's got 4 misdemeanor convictions.
Your Honor, he's sitting here because he's been revoked on a petty theft, not because of this criminal mischief. So even if he pleads this criminal mischief, he's not getting out of jail because he's been revoked on another case.
He said he was at court this morning. Is there any notes that that case was no prost?
I have it set to plea on June 3rd. He was at pretrial today, or yesterday, it looks like.
All right. Counsel for the defense.
He has informed me, Your Honor, Mr. Strickland did plead today at that court hearing.
Well, why don't you look it up? Because, you know, I'm operating with 2 different perspectives, and I think the state actually might, you know, have a better information than he does. If he's going to court on June 3rd, I would recommend that you motion the court to add this to the docket and resolve everything at one time.
Your Honor, according to my case management system as well as the clerk system, he did not plea out yesterday, and it is set for a plea hearing in front of Judge Allen on June 3rd.
Well, it is possible sometimes that they haven't updated their information yet.
May I please address the court, Your Honor?
Sir,
So
I advise
yesterday.
against that. I wouldn't do that.
No, I understand. Thank you very much for your advice.
you know, you've got a significant criminal history, sir. I'm not going to be extremely persuaded by what you say.
No, I understand this. I was just going to say that I did have court for the petty theft yesterday, but they weren't able to get me in, and they moved it to today. So today, this morning, I had just came from down. I had just got off the van from downtown court, and I pleaded no contest to the petty theft today, and they said there would be no conviction on my record, but I still have to pay the court fees, and they put me on a payment plan to pay the court fees. I have to pay $20 every month I have 6 months to pay. I am willing today, Emmanuel Bartholomew Strickland, I am willing to plead guilty to this here for the criminal mischief because I am aware that I have been struggling with a problem with alcohol, and I am willing to go out and get myself into some sort of program, and I will attend court from the outside if necessary at the downtown Orange County court room. But I really do, I'm going to get myself some help with this alcohol problem.
Right, that's, can the jail staff confirm that he went downtown today?
Yes, Your Honor. I was just informed by the court officers, and it does show in his scheduling that he did go for a plea this morning.
Okay.
You know the case number on that, Adam?
What?
You know the case number by chance?
A case number?
Yeah, because
Yes, the petty theft no longer exists. I no longer have to attend court for that, but I do have to just pay the court I have to
Sir,
pay the court.
we don't need your repeat of the information that you already told us.
It's
I
2021
apologize.
MM 2135AO.
All right.
Thank you.
Counsel for the defense,
Yes, Your Honor.
I don't know what the factual basis for the criminal mischief is. Can you look it up and tell me?
Yes, Your Honor. Just a moment.
For the record, he just pled to another criminal mischief in February as well,
That's part of what I'm concerned about.
as well as many other things in 2021. 2 months ago, he had an open container. He had this petty theft, this criminal mischief.
All right.
Another.
You finally convinced me, State. Sir, I'm going to let it be set for pretrial because your criminal history is a problem. And I'm not sure I would go along with the 32 days anyway. It's not unusual for me to go ahead and just do 60 days if a person is continually in and out of court. So we're going to give you a court date, and hopefully everybody will have looked it over, and hopefully the state will have talked to their witness by then.
Division 81, pretrial conference, July 2nd at 9 o'clock, courtroom 4E.
All right. Edson, Ulysse. All right, so this is 2015
It's a
MM
VOP, Your Honor.
215, a VOP on a reckless. How come it's a MM on a reckless? So it's a VOP. I guess the public defender's been appointed, and we'll give him a.
We'll waive the appearance and enter a denial, Your Honor.
All right, thank you.
Division 84, VOP status, June 25th at 8:30, courtroom 4B.
All right, 33-day motions. You got to add on something?
Yes. Let's go. We'll actually think about the person.
All right, and the judicial assistant did some research on some of these, and based upon the regular judge's concern, I think that sometimes they get filed on the 32nd day instead of the 33rd day. So I should let you know that she calculated some of these.
Yes, Your Honor, sometimes we just go ahead and file ahead of time, or we just go ahead and file an INN 27. I know some of the ASAs bring that up, but they'll just go ahead and deal with it if they know they're not gonna get it by the 33rd anyway.
Okay.
Jermaine Moultrie, 21 CF 4347, notice and on filing.
Okay, we can grant the motion for release on that.
Edwin Bellamy, 21 CF 4643, notice and on filing.
Okay, that's one where the judicial assistant calculated 32 days instead of 33. Do you want another day to check or not?
No, Your Honor.
All right. Grant the motion for release.
Jonathan Roll, 21 CF 1060, filed this morning.
Motion for release is denied. Trevino,
Vanessa Trevino, 21 CF 4407, it was filed this morning.
motion for release is denied.
Ruben Rodriguez, 21 CF 4640, notice and on filing.
Motion for release is granted.
Rashawn Parks, 21 CF 4565, notice and on filing.
Motion for release granted.
Sean Ambro, 21 CF 4616, notice and on filing.
Motion for release granted.
Nestor Medina, 21 CF 2376, notice of non-filing.
Motion for release granted.
Christian Diener, 21 CF 740, it was filed yesterday.
Motion for release denied.
Antoine Atkins, 21 CF 4682, notice of non-filing.
That's another one of the clerk, or the judicial assistant counted 32 days instead of 33.
It's okay, Your Honor.
All right, motion for release granted.
Flor Cora Santiago, 21 CF 2478, notice of non-filing.
Motion for release granted.
Rashawn Parks, 21 CF 4564, a no information notice was filed.
Motion for release granted.
And then there's an add-on, 21 CF 4518, Williams, that was filed this morning.
Okay. Then motion for release is denied. What, did we have one on Andy Lang? Did we already deal with that? That's also on an add-on docket.
I only had one on the add-on docket, Your Honor. Do you have a case number?
Yes, the Andy Lang is 2021 CF 4566. And I'm sorry, but the other one, add-on, did you say that it was filed?
Williams was filed.
Okay, thank you. That'll be denied, the motion.
Angie Lang, 21 CF 4566. I think we addressed it yesterday. A no information notice was filed.
No information?
Yes.
Okay, so that motion is granted. If we didn't already do that. Okay, thank you. All right, I guess that's it for the morning. Order of 12, when do y'all want to come back?
12:45. It's an hour.
No?
1 o'clock.
It's 1 o'clock. She might actually want to eat something. And she has to do work too. Okay. I'm still not done. She's not done. Okay. 1 o'clock then. Thank you all.
Thank you, Your Honor.
So, the last of them? All right.
Yes, it was at the bottom. I'm sorry.
All right. Okay, thank you. Is this Mr. Allen?
Yes, ma'am.
Okay, sir. We have a new case, 2002-1 CF 60580. It's going to Division 16 Council. And I don't see a public defender form, but generally it's better for you to have one.
My part said he was getting me a paid lawyer.
All right, well, let's just temporarily appoint the PD so they can get the paperwork started, and whenever you get the paid lawyer in, they can substitute, okay?
Yes, ma'am.
All right. They had enough information on the new case to file the charges of resisting an officer, bond amount of 100, possession of firearm by convicted felon, bond amount of $5,000, and second count of possession of firearm by convicted felon, bond amount $150. Then there's another warrant out of Lake County,
Yes, ma'am.
which is
VOP.
19 CF 1628, and that I think is a couple of VOPs in regard to possession of firearm by convicted delinquent, count 1, and carrying concealed firearm. That particular case has no bond on the 2 counts, and you'll have to talk to the Lake County judge and lawyers about that.
Your Honor, can the state request no weapons, firearms, or ammunition on both cases?
Okay, thank you. So ordered.
24 hours. Surrender.
Sure, he's not getting out anyway, but yeah. All right. Good luck, sir. Mr. Armstrong? All right, sir. We have an add-on case, 2002-1 CF 6113. It's going to Division 16, and let's appoint the public defender on that. Evidently, there was a video in regard to allegedly burglarizing some work vehicles and taking some tools back around the 8th of April. Some of those work premises have security videos, and they were able to identify you. The bond on the burglary of a vehicle is $3,500, and the grand theft of the various equipments and tools is $150. You might end up with a detainer because I think you might be on probation in Seminole, so that this case trips that. In case you're thinking about bonding out, what might happen is they file that detainer as you're trying to bond out on this one.
Your Honor, the state will request no return to the area and no contact with the victims or witnesses.
So ordered, thank you. Well, assuming you would remember something like this from April 8th. However, if you don't remember, then there is a arrest affidavit in the file, and you can look it up on the clerk's website under records and your name, and you'll find all of the allegations.
The address was 2619 Consulate Drive.
I didn't keep notes on that. Thank you. Okay, is this Miss Austin?
Yes, ma'am.
Okay, ma'am. We have a few things. We have, I think the newest one is 2002-1 CF 4277. It's going to Division 10. And I think we're probably going to want to appoint a public defender for you on everything. Yes. That one, they have enough information to at least file the charge on a possession of cocaine, bond about $1,000, and false ID to law enforcement. We'll put that at 100 as a subsidiary bond. That was that was April 12th, and the officer had initially released you, but then later, I don't know, maybe he felt like he was too busy or something, but later he tested the supposed cocaine. It came out positive, so he went ahead and issued a affidavit for an arrest warrant.
Okay.
Then There's also 2020 CF 12854. That's in Division 17. That was a failure to appear supposedly on April 5th for a court hearing on a possession of cocaine, and the judge set the bond at 500 on that one, and given a false name, the bond at 250. Also, there's a misdemeanor that's outstanding in Division 82. And, oh wait, that's a new one. That's the newest one.
The only case that I have today, scheduled for today, is 2021 CS 4277.
I have 4277 and I have the 21 3546.
When you get a lot of paperwork, sometimes it's stuck together. But there's a 21 3546, and it looks the same. It looks like the cover sheet on the CF case that you're talking about, so it looks the same. But what it is supposedly he's trying to get her for riding a bicycle without lights. He's probably really looking for drugs, because
I didn't have any.
Don't say anything. If I'm remembering correctly, it might be OPD, and you need to be careful because they get to the point where they know that you always have drugs, so every time they see you, they want to search you because they know they're going to get another case. And I think you might be at that point.
Yes, ma'am.
And that's why he would pull you over. Well, he might pull you over anyway for bicycle without nights, but supposedly every time, and this is funny too, because supposedly every time they see you, you give them a false name, because every single one of these police reports said that. And they got to the point where they have all your false names in the database so they can track them right back to you. And that's how they figured it out. So they got a new one for paraphernalia, supposedly this glass thing that was breaking that they think is a paraphernalia, and then the false name, paraphernalia is at 500, the false name's at 100. Now, I didn't see anything come through on a violation of probation. There's a note that you might be on probation, and if you are, then if you try to bond out, you might find that there's, probation hold.
I am not. No.
Okay. All right, we got to fix something in regard to the paperwork, because sometimes when you have so many, it's sort of like we might miss a page or something. Starts to get confusing. Plus, you might have a lot of court dates, so be careful about that.
Can I ask a question?
You have the right to remain silent, and your lawyer probably wants to tell you to talk to her instead of to me, because everything's getting recorded.
Okay, so 12854, the bond is paid, correct?
Is the felony?
Yes, the failure to appear.
Oh, yeah, the failure to appear stays.
And then the MM 3546, the bond is paid.
Yeah.
Okay. Any conditions? I'm just making sure. Okay.
Thanks. Not that I care about.
Okay.
All right, is this Miss, okay, so we got a few for you, good luck. Is this Mr. Berry? Mr. Berry, right, okay, thank you, sir. So we have a new case, it's 21CF6114, it's in Division 10. And we need to appoint the public defender on this. He has got a whole pile of these cases where, he's getting mental health competency hearings, but he keeps allegedly doing it.
Yes, Your Honor. July 15th of 2020, it was determined that he was non-restorable, Your Honor. It's the competency issue. So at this point, I would ask that you take no action on the out-on bonds. I'm not sure what else can be done.
Well, I don't either, except he's like doing it everywhere. I mean, what do you want?
Yes, Your Honor.
Now, so here's what I recommend. You got about 4 cases in front of different judges, and, if you can find a family member or somebody or someplace, where somebody can try to keep him from running around and masturbating everywhere, that would be helpful, you might want to tell those judges that you got a safe place and somebody's like watching them. But, you know,
Yes, Your Honor, I understand.
is the state in agreement that we should just let them right back out?
Your Honor, I believe there's cases that defense cites regarding competency. And as to his out on bonds, I would ask that you take no action at this time, but set a reasonable bond on the one he's currently on. Upon reading the case that the defense has cited before, I believe that is what it holds.
Okay, that the case law says that if he's been found incompetent, you can't revoke him after he gets put back in jail for the same activity again?
Yes, Your Honor. The case law states the reasoning behind that is that we can't plea them out. They can't protect themselves like a normal person would be able to in the jail. They list a list of things that, because they're incompetent, they would not be able to do. And so what happens is they just sit there because we can't plea them out.
That I understand. Also, there were extremely rare occasions when I would look at the guy and say, look, I don't have another place for you because there, you know, isn't any place where maybe, you know, a person could go and not keep doing the same conduct and get, you know, other victims and things. So this lady's known him for 35 years, so maybe she knows what's up with it and she's not as freaked out. So the bond currently is $2,500. Why don't you all batch him up in front of one of whichever judge has the most of the cases, and maybe that judge can figure it out. But I think you're probably trying to look for some kind of placement that could keep him and everybody else safe.
Yes, Your Honor, I'd ask for no return to that residence and to no contact with the victim or witness.
Okay. So ordered. Good luck to you, Mr. Berry.
Did Miss Bass bond? Did Bass bond? That was before Mr. Berry? I would assume she bonded then. All right, thank you.
All right. Okay, let us know when you're ready for that private attorney case, and we'll call it. But is this Mr. Bowen?
Yeah.
Okay, sir. We have well, evidently you had some outstanding warrants, 2 from Lake County and 1 from Seminole. And as of supposedly yesterday, case number 2002-1CF6096, Division 22. And we'll appoint the public defender to represent you. Supposedly they're trying to serve the warrants and they seem to have enough information to at least file the charges of resisting an officer with violence, bond amount $1,000. And I would set the second 2 as subsidiary bonds, resisting without violence at 100 and possession of drug paraphernalia at 100. So you've got those bonds on the local charges, and the other ones, does he have? He has one here too.
He has 20 mm 991.
He does.
Orange.
Exactly. He has 20 mm 991 AW Division 80. And that has a couple of $1,000 bonds on it in regard to petty thefts. Those were the subject of an arrest warrant in regard to some stores' security cameras. I had looked at it before.
Your Honor, in regards to that case, they would ask for a no return to the Lowe's.
Okay, no return to that Lowe's. And the Lake County charges, do we have Seminole and Lake? Or is that paperwork coming through, or does he get notified of those holds later?
He has not yet been served on those. Your Honor.
All right, okay, well, sir, there's some outstanding warrants, and they're gonna serve you with those warrants later. All right?
Is everything bondable?
Yes.
You know, I haven't actually seen the paperwork for Seminole and Lake, so I don't know off the top of my head. Does,
Ready for him?
sometimes it get complicated when you get a multitude of cases.
I'm very confused. Yeah, it is very complicated.
You're confused or you're aware?
Sorry?
Okay. She's gonna tell you not to keep talking. Thank you. Is this Mr. Bradford? Okay, sir. We have a case number 2021 CF 610380. It's going to Division 20. We'll appoint the public defender, sir. And I understand they were just stopping you for not using the crosswalk, but they allegedly found cocaine and can justify a bond of $1,000. And methamphetamine, we'll put that as it's sort of an additional charge. We'll make that $150 instead of $1,000.
Your Honor, state would request no drugs or alcohol without a valid prescription.
All right, we're telling everybody not to have drugs when they're on a bond for drugs unless you have a prescription. Good luck, sir. Is this Mr. Brown? Okay.
No, Your Honor, this is
This is
Mr.
the other
McNair.
one.
Yes.
All right. Let me find it. Okay. This is case number 2021 CF 6095. Had some notes on there somewhere. Okay. And, all right, counsel, you can state your name for the record. Thank you.
Good afternoon, Judge. Daryl Smith on behalf of Mr. McNair, who's to my right.
Okay, thank you. Well, we read the affidavit.
Yes, Your Honor, I had an opportunity to read it as well. I got a copy from the clerks. The defense doesn't have an argument as to probable cause. I'll just put on the record that Mr. McNair is 18. He's actually, he just received a scholarship to attend Grambling University in the fall. He was here with his family on a vacation to celebrate his graduation. He has no criminal history, no prior failures to appear, anything of that nature. So I would ask the court to set a bond at $2,500.
Your Honor, this is a first-degree felony. So I would say that the bond of $2,500 is a little low. State would ask for 10 grand.
All right, well, his parents are well organized enough to get a lawyer. Part of the problem, counsel, is that from Louisiana, we generally want to make sure that the bondsman has sufficient security to get him back. So I think that the bond suggested by the state is reasonable in that regard.
And Your Honor, if I may, I think most of the time with out-of-state people, what the bondsmen do is they require them to either put up collateral or a large portion, if not all of the bond up front. So that's the reason why I was asking for the $2,500. If Your Honor would consider maybe somewhere in the middle, if Your Honor is inclined to do a higher bond.
I mean, it's a substantial charge, first-degree felony.
Understood, Judge. I mean,
No, I'm sorry, the parents are the ones who are going to be punished, really.
Understood, Judge. I mean, I don't want to kind of downplay the facts, but for a first-degree felony, the allegations are not of a particularly egregious nature for a sex case, if I may say.
Well, that might be a subjective opinion, you know. Other people might have a different opinion. my first reaction is there must be something particularly immature about this young man. But it's a very serious charge. And I'm concerned about it being minimized in the eyes of him or his family as well, as being consistent with the kinds of bonds that we set on cases with this particular charge. I'll go along with the state's suggestion. I understand what you're saying. It's a very serious charge, and he and the family need to know that, especially him. This is not something that you can do, period. And clearly the state is going to request, and I'll order, no contact with this alleged victim. You may not even know her name, but, and don't go back to those premises where your family was on vacation. Make sure you come back for all your court hearings. So yeah, they're going to have to put up a grand and have some collateral, probably.
Your Honor, state would also ask for no contact with minors unsupervised.
Unfortunately, that's a fairly standard condition. Do you have any children in the family?
He has siblings, Judge. He has three, at least two younger brothers. I believe he has a younger cousin they all came to my office earlier. They appear to be all minors. I mean, I would ask the court to make an exception for his relatives.
Are any of them girls?
No, I was going to say they're all males as well.
Okay.
Or boys, I should
Court
say.
will make an exception for the relatives that he's traveling with, given his lack of other history. Good luck.
Thank you, Judge.
You're welcome. His family members did that. Okay. Oh. Is this Mr. Brown? Okay, thank you, sir. The new case is 2021 CF 6102. It's going to Division 16, and you do qualify for the public defender will appoint their office to represent you. They have enough information to file a charge of possession of methamphetamine. Is that coming in at a higher bond than cocaine? I'm used to 1,000, and it said 2,500 on the police report.
No, usually methamphetamine is treated the same way as cocaine, Your Honor. I believe it's potentially because he's out on bond for use alone and resisting without.
Oh, so he might have just doubled it because the out on bond status?
Potentially, Your Honor.
Right, okay, I was wondering. Well, then, how about we set it at the regular bond amount of 1,000 on the new one? He is out on bond, as you mentioned, on what has been filed as count 1, possession of Ulysse, count 2, resisting without violence, and I believe he's got a public defender on those. He's actually got a return date of June 10th. Now, Mr. Brown, at one point you were released on that, but what happens sometimes is the paperwork does get filed later by the state, so that case is still going on. And
I see that he has arraignment on his add-on bond case on the 27th.
oh, really? I thought it was of this month?
Yes, Your Honor, that's what I have in my system.
All right, so he's got some other hearing on June 10th also, maybe.
Oh, they canceled the arraignment on the 27th and moved it to the 10th.
10th, okay, so, sir, I took a look at your history as well. You know that when you're on a bond on a charge and you get a new charge that a lot of times you'll be just revoked. I'm not going to revoke it, but I'll double what the original amount would have been. So on the possession of you alone, it'll be 2,000. On the resisting, it'll be 100. I would note that you have a hearing on the 10th of June on that if you don't make bond.
Your Honor, is it going to be 100 or 200?
I'm sorry. I just had 100. I was going through them kind of fast. I don't think it's going to make a big difference to them.
Yes, Your Honor.
Thank you.
So that was 2,000 and 100 on the out on bond.
Out on bond. Thank you very much for clarifying that. Yeah, but evidently, Ms. Carson bonded. Is this Mr. Davis?
Yes, ma'am.
Okay. Sir, we have case number 21 CF 6090, and it's going to Division 19. You do qualify for the public defender. I'll appoint their office to represent you. I read the report, sir, and you do qualify for pretrial release because he still qualifies, right?
Yes, Your Honor.
Okay, sometimes we come to court and they've made a different decision, but, so you don't have much criminal history, and so you can get out without post bond and talk to your lawyers about this. I understand that there's two different stories here, and ironically, not only is there two different versions from you and the old white guy, we'll call him, who supposedly was being real racist, but there's actually two different store employees, one of whom thought the old white guy was really, like stomach bumping you and like aggravating the situation, even past whatever happened in the store. But another one thought that you were the aggressor. But there's a video. So that's what the final determination is going to be. I would just say this to you, sir. If a guy's being racist, you can't fix stupid. Just leave him alone, okay? I mean, I know everybody's upset now because, everybody's talking about this stuff, but the guy's a racist, he's a racist. He's not, you just have to wait for those people to die. You can't fix him. And I'm sorry that, you have to deal with that kind of crap, but you can't go around and be the hall monitor of the universe. I think your lawyers will be able to figure out how to deal with this. Good luck.
Can I ask a question? Your
Don't do anything else while you're out.
Any conditions, Your Honor?
You can get out without post and bond. Yeah?
Any conditions?
Your Honor, state would ask for a no contact as well as a no return.
Yeah. Don't have any more words with the old white guy. Oh, okay. Yeah. I mean, they were just at the store. It's not like they knew each other. Okay. So there was a Jane Doe whose name is Laura Simon, but she's medical or something? Okay. All right. It's 2002-1 CF 6104, Division 22. And let's appoint the public defender. And,
I'll waive the appearance, Your Honor.
all right, so I think I already asked you this before, forgive me. We're doing 2,500 on Bat Leos now?
Yes, Your Honor, I do believe that's
That's normal, okay. All right, we'll sustain it at 2,500 on the Bat Leo and 100 on the resisting without. Is this Mr. Evern? Thank you. Is this Mr. Favors? Okay, thank you, sir. All right, I think we got two different police reports for the same incident. One's in traffic and one's in felony. The public defender form says you get $850 a week working. I couldn't hear it.
Probably lost my job. I probably even stand permit right now.
Okay. I'll take that into consideration and appoint the public defender if you like. Okay. If you don't lose your job and you get an attorney, just have them substitute in for the public defender. On the felony, it's 2002-1 CF 606780, possession of cocaine. They've got enough information to file the charge. Bond is 1,000. Then the leaving the scene, they have enough information on that. It's 2002-1 CT 3783, Division 84. They can file that one also. Bond on that one is 1,000. Sir, if you bond out, you're going to have two different court dates, one in traffic and one in felony. And it's too complicated to explain, but that's the way it goes.
Your Honor, the state will request no drugs or alcohol without a valid prescription.
All right. She's asking for that, and I've been ordering it routinely. Good luck to you, sir. Yeah, that's fine. Is this Mr. Florent?
Yeah.
Okay, sir. Let's go ahead and appoint the public defender for you. In case number 2002-1 CF 608280, he's charged with that. He continues to come back. Maybe, I don't know if he got evicted from the apartments or just likes him there, but he just keeps coming back,
Yes, Your Honor.
sleeping.
I did have for the burglary of a dwelling PC challenge. Based on the jury instructions that I was reading, the defendant, in order for the state to prove a burglary, he must enter a structure or conveyance owned by or in the possession of someone, and at the time of entering that structure, he had the intent to commit a crime other than a trespass or a burglary. Upon reading the arrest affidavit, the only crime is the trespass that is also listed on the arrest affidavit, but I don't see any other crime committed other than him sleeping in the property. It stated that there was significant damage to the unit, but that was a previous incident under a different case number.
Was it the same? But it was.
It wasn't the same.
The same guy, though. I was wondering if it, he used to have the apartment. What happens is they used to have the apartment, they get evicted, they trash it, because it's like a passive, or not even a passive aggressive act. They just trash the place because they're angry. But you're right. I mean, it could have been the prior one. We don't really know if he trashed it the first time or the second time. I wasn't 100% sure. It did seem like he keeps coming back to that place, which is one reason why I thought he might have gotten evicted, because that's what, it happens.
Your Honor, as to the intent element, I would just argue that is a question for the jury, for them to determine if he had the intent to commit any crimes while in the unit. He keeps going back to the unit, which I think could show at least an intent to do something in there.
Do something. You think that meets the probable cause standard?
I mean, he entered at least surreptitious.
Yeah, we get it. It's a long day.
It's a very hard word.
Long day.
Into the unit and slept in a place that he wasn't allowed to be. And I would just argue that intent is a jury question for the jury to determine if you had other intent to commit a crime in that unit, since he already knew he was not allowed to be there.
Well, I think the defense counsel made a good point, and
Your Honor, potentially he's loitering in an area that he's not allowed to be in.
that's the same thing as trespass in this case. We're just calling it a different name.
Arguably under the statute, it's not, Your Honor.
Well, state could you file whatever you want. I'm not doing anything that controls that situation, and then you can still have your shot in front of the jury. I think she's made a pretty good point. I want to give her one here, and find probable cause for trespass. He's got quite the history, and he keeps going back, and I think these people are probably thoroughly tired of it, especially with the damage. So I'll set bond at 1,000 on that. And since we now have 2 trespass counts, I just ROR him on the second one.
Your Honor, I thought you would just find no PC to count 1 and find 1,000 on count.
Well, I could do that. No PCS to count 1, thank you, that's much clearer. And then 1,000 on the trespass.
Your Honor, state would ask for no return to the property.
Well, Mr. Florent, if you keep going back, we'll keep messing with you and make you post bond. All right? They're tired of it, so,
So let's go count 1 is ROR.
yeah, thank you. Thanks for clarifying that. Is this Mr. Hallback?
Yes, ma'am.
All right, sir, thank you. We have 2021 CF 6053, and I don't have a public defender form, but you need one.
He filled one out. Good.
Oh, he filled one out?
He qualified.
Okay, you qualify for the public defender, sir. We're going to appoint their office to represent you. I know, now you don't have to say anything about your case. You have the right to remain silent, sir. I know that you told officers that they were threatening you, but you can't be taking matters in your own hands.
Yes, ma'am.
Now they got enough information to file the charges of aggravated assault with a firearm, shooting from a vehicle, and criminal mischief. You had one prior juvenile possession of a weapon in 2017, so I guess this is one of those cases of young men carrying guns around. Just lucky that nobody got killed, because we've got way too much of that going on. Way too much. So, counsel, how about, I was thinking about staying the bond at 5,000 on count 2. I don't know if his parents are gonna bail him out or not.
Your Honor, these are aggravated circumstances, and since there were discharges, I would ask for you at least to stay count 2 and to set count 1 a higher bond than a subsidiary due to the gravity of this offense.
Yeah, I put like 3 different choices there, because I just, I don't know much about him, but the problem is that we just have too many kids shooting each other. How about I compromise and put it at 1,000?
On count 1?
Yeah. And then 150 on the criminal mischief. Evidently, this lady's car got shot up pretty good.
Thank you, Your Honor. So you're leaving the bond on count 2?
Yeah, I am.
Your Honor, state would ask for no weapons, firearms, or ammunition, as well as a no return, as well as no contact with any of the victims or witnesses.
Did you hear that, Mr. Hallback?
Yes, ma'am.
All right, those will be ordered on your paperwork. Oh, she said that no contact with victims or witnesses, don't have any more guns, like, hopefully you listened about that. And,
No return.
don't return to that area. If you have any more guns, surrender them to the care of the arresting law enforcement agency within 24 hours of any release.
Yes, ma'am.
Thank you. Is this Mr. Hooks? Okay. We have an add-on charge, case number 2021, CF 6072. This one's going to Division 17, Public Defenders appointed. This was a warrant signed by another judge in relation to some sworn affidavit for arrest warrant in relation to a number of charges that would have happened in February 2021. Did the state wish to be heard?
Yes, Your Honor. As to count 1, it is a PBL, and as to count 2 being a life offense, state would ask that you hold him no bond pending an Arthur hearing. I do believe he's already being held due to some of the other cases he has.
I was, because he's got so many other charges, I figured I'd just leave it where it is and let you all take it downtown rather than try to pick and choose.
Yes, Your Honor. That's why I've just asked for you to set no bond on 1 and 2, and then reasonable bonds on all the rest since he is entitled to them. On 3, 4, and 5, and then stay 6.
All right, I was going to leave them where they are, but count 1, attempted first-degree murder with a firearm, first punishable by life. There's sufficient evidence to hold him at no bond at this time. Count 2, kidnap with intent to inflict harm or terror with a firearm. There's sufficient proof to hold at no bond at this time. Count 3, ag battery with great bodily harm with a firearm. We'll put that at 150. Count 4, aggravated assault with a firearm. We'll put that at 150. Count 5, false imprisonment with a weapon will be 150 because he's entitled to a bond. Count 6, witness tampering at 1,000. Don't have any contact with the alleged victim. Don't possess or own any weapons or firearms. And it's just added on to the other things, sir. So talk to your lawyers about it. All eventually be dealt with as a package downtown.
This is crazy. I don't understand how all of a sudden it just changed. With 2 months to be sitting here, everything just changed. That don't make sense.
Is this Mr. Jackson?
Yes, ma'am.
All right, sir. We have a new charge of 2021 CF 6086. We'll appoint public defender to represent you. And,
Your Honor.
yes, ma'am. Division 22.
Your Honor, for the possession of the anti-shoplifting inventory control device, there were pliers that he picked up in the store that were unable to even cut the, I don't know if it was what the laptop was connected to. And in order to have an anti-shoplifting or inventory device countermeasure, it means any item device which is designed, manufactured, modified, or altered to defeat an anti-shoplifting or inventory control device. Here, he picked it up off of the shelf, tried to cut the wire connected to the laptop, which didn't work. So, Your Honor, I would argue no PC for the pliers being an anti-shoplifting device where they were not designed, manufactured, modified, or altered to defeat the anti-shoplifting or inventory control.
Well, I think that the intentions were to use a more generic implement for the purpose of shoplifting, and that probably gets past the probable cause standard. You can always argue it to a jury, but...
Your Honor, there's also another definition of an anti-shoplifting or inventory control device in that same statute, that it's a mechanism or other device operating for the purpose of detecting the removal of an establishment or similar enclosure or to take off tagged merchandise. This includes electronic or digital imaging. I I would just argue that the pliers were picked up for that purpose and intended for that purpose. Therefore, they are an anti-shoplifting device.
Okay. I think we can get past the probable cause challenge on that particular count. So I'd find probable cause for possession of anti-shoplifting device. Stay the bond at 1,000 on that, 100 on the petty theft. That's in Division 22. We've got, the other problem is that he's out on a theft charge.
We would just ask that you revoke and double the bond amount.
That's 2021 CF 798.
He has no failures to appear, Your Honor.
He's got 26 felony convictions, 15 misdemeanor, and 77 unknown. He's been to DOC 4 times.
And a significant theft history, Your Honor. His last conviction was for a grand theft and a petty theft 2 prior.
Is he actually going to get out?
Yes, Your Honor. His grandkids.
He's got grandkids?
Yeah, they're gonna,
Want him out?
I'm from Louisville, Kentucky, and my grandkids are coming down to see me this weekend. Please, man, don't revoke.
Oh, you want to get out to see your grandkids?
Yes, Your Honor.
That I haven't seen since 2016.
Well, you know, I just became a grandmother myself, and I understand how important that is. And when are you going to learn, Mr. Jackson? This is crazy. This is just crazy. Absolutely nuts.
It is.
You're way too old for this stupid crap.
I mean, I have to agree.
Even the woman in the gallery's like, "You're right, Judge." On her head. Like, I don't know, it's particularly pathetic to say, you know, I want my grandchildren to see me.
It's the truth.
Well, I hope being messed with by a female judge is enough to get your attention. I'm going to double the bond on that one. It's your lucky day, sir, because you know darn well that most judges would just no bond you. So if you do something stupid again, you'll be back and it won't be me, because I'm just a substitute judge.
Your Honor, so you're setting it at 2,000?
2,000, another one at 1, and, you know.
Wait, the out-on bond is 2,000? There was only one count of grand theft.
Right.
Okay.
The new one is the one for the shoplifting device.
Yes, Your Honor, and that's 1,100.
1,100, and don't return back to those stores. And don't shoplift anymore.
Be said. It's gotta be said.
I know you gotta say it or something. I just feel stupid. This thing's been doing it for a long time. Okay, is this Mr. Jimenez? Okay. Oh, no wonder he's confused. It's not him. Okay. So the new case is 2021 CF 6107. We'll appoint the public defender.
Your Honor, I'll waive the appearance. However, on the out-on bond charges, she has been deemed incompetent to proceed by Dr. Ruiz, December 14th of 2020. So she did have a new evaluation, which deemed her still incompetent to proceed. Due to the fact that she is picking up relatively nonviolent offenses, and from what I can see, she's unemployed, I would just ask for an ROR and order that she stays in contact with the public defender's office for all future court dates.
Has she been deemed incompetent by the court?
Yes.
Or has it been like a private evaluation and then you guys got another evaluation? Has she actually been found incompetent by the court?
From what I read, yes, and I'll double check.
Well, you're asking me to ROR her on the new cocaine charge?
Yes, because she's incompetent, Your Honor, and it seems that she's unemployed. From what I gathered, all of her, all of the out-on bonds, they're nonviolent offenses. They're,
I heard it once.
yeah, she's not a threat to society.
The clerk found, or the jail staff found a fourth one, by the way, that I can give you the case number on.
Another add-on bond?
Yeah, another out on
Oh,
bond.
another one?
2021 MM 2811AO is another trespass after warning.
Yes, Your Honor, I have that on my face sheet. I have a trespass, a possession of cocaine, a trespass.
It's a second
and a
oh, you got
dwellers.
2 trespasses?
Yes, Your Honor.
Okay. All right, so they just handed me, I don't have it on the initial appearance sheet that I have, so I just have now got the second trespass. So 2 trespasses are 2021 MM 3011 and 2021 MM 2811. And she's also got the possession of cocaine, 2021 CFA 04, and driving while license suspended, 2020 4607.
I see there was an order signed by Judge Bigney in the 3011 case.
Finding her incompetent?
Adopting the findings. Sorry, I'm reopening it. I just closed it. Judging the defendant incompetent and placing her on conditional release. That was on May 10th in the 3011 case.
Well,
April 30th, 2021, it was the same thing on the 21, 2811 case.
So the case law that you referred to, that I'm not always getting when I'm retired, basically, does that refer to the cases that the person is currently out on bond on?
Correct, Your Honor.
It doesn't necessarily constrain the court on the new charge?
Yes, it's the
No.
ones that they're out on bond on and they have been adjudicated by the court, not just, there hasn't just been an
Right.
order from one doctor.
Why don't we just take no action on the one she's out on bond for? Set the bond at 1,000 on possession of cocaine, 100 on paraphernalia. I understand the issues in regard to mental health, believe me. I just think that, when she keeps getting the charges, they need to be rounded up. You probably need to try to put them all in front of one judge and then see if there's any placement anywhere, any family member, anybody who can try to get her to take prescribed medication instead of self-medicating and trespassing and driving when she's supposedly incompetent and on drugs.
Yes, Your Honor.
All right, good luck. Is it Mr. Lattimore? Okay. He keeps looking at me like I'm crazy or something. We just have a bunch of people here. All right, well, is it Mr. Lewis? Okay. I guess you might as well stand there against that wall for a while. We'll see when we get to you. Okay.
Who's next?
So Mr. Lewis refused? Yes. All right. 2021 CF 6063AO. Let's appoint the public defender. The new charge is an alleged petty theft, second or more. It's in Division 22. They have enough information to file the charge.
I'll waive the appearance, Your Honor.
All right. So, bond amount is 1,000 on that. And he was out on bond.
Yes, Your Honor. I asked the state to see if the information had been filed. I didn't see any information filed on that case.
It has not yet been.
There's no information filed, so I ask that you take no action on that case, Your Honor.
All right. Let's take no action on the out on bond since it hadn't been filed.
And state we just requested no return, Your Honor.
Don't return to that store. Thank you. Okay, it's Mr. Lopez Medina, right? Okay, thank you, sir. The case number is 2020 CF 13168, and it's in Division 10. Looks like you probably previously had a public defender, because this is a failure to appear warrant in regard to a case management conference from the 19th of May, and on a fleeing and attempting to elude. So judge put it at no bond.
Can I explain myself, sir, please?
Like you didn't get notice?
Let me explain to you. On the 19th was supposed to be Monday. I was supposed to be in court with the lawyer. On the 24th, I was supposed to have another appointment to be show up. I called the lawyer early because I was told that the Monday appointment was canceled. In that interim situation, I called my bail bond on Wednesday, the day of the my second. It was supposed to be my second hearing within the 24th, and he said that show up on Monday on the 24th because the Wednesday meeting was canceled. That's what the
So it got mixed up.
miscommunication took place. And then he didn't arrest me. He said, "I'll see you Monday in court." I told him, "Do you want me to show up at your office right now?" He said, "No. Play role. I'll see you Monday." And look at where I am.
Right. I think I'm gonna
it was
need,
no communication.
you're not gonna need to go downtown and tell that judge, because they don't like it
Well,
when I
I'm just
do
telling
something
you,
here.
I just explained to you what happened exactly.
I get it.
I even called
I get
them.
it.
I got in my record in my phone, record of the call on my phone,
Okay.
discussing this. So it wasn't, I never run from the system. You will have my record. You will never have a failure to appear in court. No here, nowhere. I always show. I don't have to run. I don't need to run. I will not run.
You mess up.
Amen. Oh, sorry.
Oh, all right. I just get in trouble when I touch those judges' bonds, so what I do.
I'm just letting you know, Your Honor.
Okay.
To be honest, I never fell in the system.
Well, I heard it
always
the
show,
first time.
And this is a failure of a communication directly between.
Okay, I heard it, that the repetition doesn't help. I'm still gonna send you downtown to talk to that judge.
But you
because-
will give me a bond today.
No, because I get in trouble when I touch their bonds.
Come on, Your Honor. I'm trying to be honest and fair and square with you here. My bail bond is right there that he
The
even.
repetition is not gonna help. I'm not touching it. I have to trust your lawyer that, about 50% of the time when people say the lawyer gave them the wrong information, or it was a mix-up.
So you are not giving me a
That
bond?
might be true, it might not,
Your Honor, just for
So
the
you gotta
record.
talk to that judge, and your lawyers will get you in front of that judge pretty soon.
Yes.
What happened?
Your lawyers will get you in front of that judge pretty soon. I know sometimes it's a legitimate misunderstanding, but a lot of times it's not.
It wasn't, Your Honor.
It wasn't the lawyer's fault this time?
No, Your
Okay. Mr. Luna?
Hello, Your Honor.
Hello, sir.
Hello.
It's case number 2021 CF 6106. And, let's see. You put an amount down, I'm looking at the public defender application. Is that how much you make per week?
Yes.
Okay. So, well, the good news is you do pretty well, and the bad news, you might not qualify for the public defender, but I think you might.
I believe he has his
He has
own
a
business,
private- Your Honor. Yeah, he has a private attorney on the out-on bond, Your Honor. So I believe he will be able to afford an attorney.
Wait, is this Mr. Luna? I don't have an out on bond.
Yes, Your Honor, I'm just about to give it to you now. He's out of bond for a DUI.
Okay. Okay. He's on pretrial release.
Yes.
The out on bond is 2020 CT 834 AE, PTR. It's got Miss Belani. So Oh, that's right, I see. All right, no convictions yet, but he's had some charges in the past. So, all right. In regard to the new one, sir, let's just stay the bond at 1,000. In regard to the DUI, I know those take a while sometimes, especially when you can't get cases on a trial docket.
Your Honor, state would just ask that you revoke, and if you're inclined to double.
Well, it was PTR, so the question is whether it's 500 or more.
Revoke, and I believe it would have came in at 500 due to being a first DUI.
Oh, so you're asking for 1,000?
Yes, Your Honor.
Oh, that's fairly normal, sir. So let's give you 1,000 and 1,000. You can bond out. Talk to Ms. Belani about your second case. And now you'll have different court dates in the different courts.
Okay.
One in felony and one in traffic. You're welcome. Okay, we already did Mr. McNair. Is this Mr. Pearson? Okay. Counsel, did you want me to disappoint the public defender on this, Mr. Pearson's?
Yes, Your Honor.
All right. It's case number 2021 CF 6066. I did look at the affidavit for the arrest warrant. They have enough proof and presumption to hold him no bond at this time on a first-degree murder charge with a firearm. So we'll do that, appoint the public defender.
Your Honor?
Yes.
I'll waive, because I didn't wait, I'll waive his appearance. I don't think I said it.
Okay.
His appearance.
All right.
Your Honor, state would just ask for no contact with the victim, witnesses, or any of the victim's family.
Well, the victim is deceased.
Yes, victim's family.
All right. No contact with the victim's family. Is this Mr. Panthany? All right, sir. Case number 2021 CF 6054. Let's go ahead, and I'm not seeing a public defender form, but I think you probably need one. So let's go ahead and appoint the public defender on the new charge. They have enough information to file the charge of possession of fentanyl. Count 1, bond 1,000, possession of paraphernalia, count 2, 100, and it's going to Division 14.
Your Honor, state would ask for no drugs or alcohol without a valid prescription.
No more drugs without a prescription. I'm not trying to make light of it, I just... You're out on bond for a couple things. At least a couple, or is it 2 or is it 3?
I have 2 cases, Your Honor.
All right, thank you. Okay, let's at least double them. It's a violation of release conditions to get a new criminal law violation while you're out on bond. Instead of revoking them entirely,
Your Honor, count in 21 CF 2781, count 1 was $1,000 bond. So you're going to set it at 2?
dealing with what, 20?
The petty theft to Pryor was count 1. It was set at $1,000.
All right, and then
Count 2 was the dealing in stolen property, and it was set at $2,500. And count 3 was receiving money from a pawnbroker by false verification, and it was...
it had been 1,000.
Yeah, Your Honor,
No?
we just filed a no information on that.
On which one?
That case is no longer active.
It what? You have a no information on that one?
On the 21 CF 2781, we filed a no information.
Okay.
All right, so I think we're going back and forth between the cases. So 14721 is a no info?
No, 2781.
2781. That's a no info?
Yes, Your Honor.
Okay. We won't take any action on the bond then.
And then as to the 20
202014721.
the bond was originally 1,000.
All right.
Did you file on that one as well?
We did.
All right, let's just double it to 2,000, sir. Looks like he's had some failures to appear. All right, good luck. Okay, is this Mr. Ryan?
Yes, ma'am.
All right, sir. We have a new case, 2021 CF 6099AO. It's a possession of methamphetamine, and we need to appoint the public defender for you on that.
Yes, ma'am.
It looks like they have enough information to file that charge. And bond amount on that. Where is that? Is $1,000. That's going to Division 10. Counsel, you might have a couple of, is it one or two cases on probation? You have the, when the officer knows that you're on probation and you get a new charge, they might file what they call an on-view violation of probation. Trying to figure out if this is local or if it's in another county. Seminole County. So, and I imagine the clerk has the case number, or the jail has the case number on those. So what we'll do is we'll enter a no bond status on the violation of probation, because it's going to happen anyway, even if you try to bond out on the new one.
Your Honor, I also believe he has some reporting requirements.
All right, sir, if you have some reporting requirements, if you know what I'm talking about.
No, ma'am, I don't.
Okay. Or you want to tell him? Okay.
Thank you, Your Honor.
Thank you. Good luck to you, sir.
Thank you, ma'am. I appreciate it.
You're welcome. Mr. Shepherd?
Good morning, Judge. Good afternoon, I'm sorry.
Yeah, it is hard to tell in here, isn't it?
Mm-hmm.
Okay, thank you. All right, thank you. Mr. Shepherd, we have a local case here, and then we have one violation of pretrial release from Manatee County that we need to tell you about.
Yes, ma'am.
In regard to the local one, we're going to appoint the public defender.
Yes, ma'am. And could I have a word about the local case, please, whenever you get a chance?
A word?
Yes. Could I just give a speech about not a word, but could I have a say so about the local case? I just have something to tell you. Explain.
Well, you might want to talk about it to the lawyer, because number one, I can't do anything to the charge. All I'm
Yeah.
doing is seeing if there's enough information to file the charge.
Yeah.
And making sure the bond is fair. You're at a very high risk of saying something that might accidentally help the state convict you, so talk to your lawyer about it instead. Putting it on the recording of this hearing, which could be played back at your trial. Talk to the lawyer about it instead.
I was gonna say, so I have to wait the minute he kind of come get me?
You have, what,
Yes.
you're asking if you have to wait?
Yeah.
Pretty much. It appears that they verified that you might have been driving a stolen motor vehicle, so they got enough at least to, like possession and driving it is enough to cause you to have to post a bond of $1,000 on grand theft motor vehicle. That case is in Division 20.
Your Honor, state would ask for no contact with victims, witnesses, or co-defendants. In this case, I believe it's Mr. Latarian Shepherd.
Okay, thank you.
Ma'am?
You might want to talk to your lawyer.
Yeah, but it was just on what you said, but I'm saying even on my affidavit, it say I wasn't driving. How come I get a stolen vehicle charge for operating a motor vehicle, even though I wasn't even driving a motor vehicle? And it say on my paper, the deputy got me out of the passenger. I never was operating a motor vehicle. It say the deputy got me out of the passenger seat of the motor vehicle on my affidavit. So I want to know, how am I getting charged with a felony offense? And me not aware, not knowing the car was stolen either, that's another thing. Like, how am I keep just getting charged with?
It's too bad you're not using that intellectual capacity for a better profession, sir. I can see what you've been doing from your criminal history. It sounds like a waste of talent to me.
No, ma'am.
All right, let me look at it.
Your Honor, the state would just respond to that, and that he's in possession of recently stolen property. So the stolen property can be attributed to him, even if he's not.
Okay.
He's in possession of recently stolen property, Your Honor. So the
You mean
possession of vehicle can be attributed to him, even though he's in the passenger seat.
For him being in a passenger seat?
Yes, Your Honor.
Damn, boy.
Has something changed?
I didn't,
It used to be that you get a trespass.
yeah. I just,
I'm absolutely aware that the case law could have changed since the last time I looked at it.
Your Honor, I would argue that it was just a trespass, but I'm pulling back up the arrest affidavit.
Let me see who was driving. He was exiting the driver's seat.
That was Latarian Shepherd, Your Honor. I believe it was
Oh.
Other person.
a brother or a cousin or something, maybe.
Oh, I see. There's Daquan and then there's Latarian.
Yes.
And he's in, Daquan is in the, okay. By the time we get to the end of the felonies, I'm reading too fast.
Your Honor, the state would just have to show that he had knowledge that it was stolen. I'd argue that he would know it was
No,
stolen. Due to, one, it being 4 a.m., and two, the fleeing at over 115 miles per hour from law enforcement.
Oh, he probably knew it was stolen. Only question is whether he, I suppose they're going to try to implicate him because, you know, like a co-conspirator.
Your Honor, we could charge it under principal theory and show that he had knowledge that he knew it was stolen.
It's crazy.
Maybe, maybe not, sir. I've been off the bench for a few years and they brought me
Sorry, Your Honor, I
back.
didn't mean to interrupt you.
Well, I mean, I don't care if you interrupt me or not. I'm going to do the best I can with it. And, that's a good question. They pull me out of retirement to help sometimes, sir. And so, not knowing if the case law has changed, I'm going to go ahead and find probable cause for trespass in a stolen motor vehicle, which is what we used to call it.
Thank you, Your Honor.
I'm not real happy with your criminal history. Where, do these young men live locally? St. Pete.
Ma'am, I live in St. Pete.
It sounds like a failure to appear about to happen with this prior criminal history. Sir, I'm going to still leave it at 1,000.
It's 2 failures to appear, one of which is.
I'm just, and he's got a violation of pretrial release on the one from Manatee County. Sir,
Yes, ma'am, but
what a waste. You're obviously intelligent. Can you not figure out something else to do with yourself?
no, ma'am, but if I keep.
No, don't talk about what I don't want you to incriminate yourself. Just,
No, I'm not.
you got to find something else to do. Because it's, if you haven't gone to prison yet, you're really working on it. And you're way too young for that. You don't want to go up there with those really bad dudes for stupid stuff like this.
Yes, ma'am.
They'll turn you into something else. Then, you won't even be a normal human being by the time you get out of there.
Your Honor, sir, are you finding trespass in a conveyance?
Yeah, I'm finding the trespass and leaving the bond at 1,000 because I'm worried about all these open cases. I mean, this man he's got a really strong work ethic in the wrong field.
For the clerk, trespassing conveyance is 810.08.
All right, and then there's this no bond on the violation of pretrial release in Manatee County, sir. So I can't do anything about that. I just hope you figure this out before you end up in prison.
Yes, ma'am.
Good luck. You're welcome. All right. So now the next is the brother. Okay. Let's appoint a public defender to him too also. One of them will probably get the conflict counsel. And this is amazing because he doesn't have much history and his brother really does.
Your Honor, I'll waive the appearance. He doesn't have any criminal history. He does qualify for pretrial release. I would ask for pretrial release in this case, given the lack of criminal history.
Wow, that fleeing attempting to elude was pretty major too. Holy cow, I'm not used to the pretrial release on that.
Your Honor, just because he qualifies doesn't mean you have to put him on it. It just means that the charge qualifies.
Holy cow. All right, it's Division 11, counsel.
If you're inclined to put him on PTR, I'd also ask for bond. It was a fairly significant fleeing and eluding. It was particularly dangerous. They were doing speeds of, I believe, 115 and then 100 on the off-ramp, causing the car to fly into the air and disable it.
Yeah, I can't, I don't know that he's entitled. I understand some things are changing, but I think might be a more aggravated fleeing attempting to elude. I'm more at 2,000 on the fleeing attempting to elude, 150 on the vehicle theft as a subsidiary.
Your Honor, state would ask for PTR in conjunction with that.
Plus PTR? What? For what purpose? Just a supervising?
Just for the bond. If you're going to set the bond that high, Your Honor, with no criminal history, I would ask for straight bond amounts. I would not ask for pretrial release and bond.
I'll go with the bond amount. I'll split
Thank
the
you.
baby in half on that. All right. Is this Mr. Thomas? Thank you very much. Is it Mr. Vedder?
Ma'am.
All right, sir. We have case number 2002-1 CF2373. And sir, this is in Division 20. I think you might have already had the public defender.
Yes, sir.
Okay, thanks. Evidently, you had a possession of fentanyl and drug paraphernalia that you were out on bond on and failed to appear for pretrial on the 17th of May. The judge put the bond at $500 on the possession of fentanyl and $100 on the possession of drug paraphernalia. So if you
I,
bond out, be careful about your court dates.
I know, ma'am. I had gotten hip replacement surgery. I broke my hip like 3 days before I was supposed to go to court. And I had called my public defender. Because that's all I could do from the hospital. I called my public defender,
All right.
Brian Wynn, and to let him know that, because I wasn't able to walk at that time.
I believe it. I understand that. I guess you don't have any prior criminal history, so,
No, Your Honor, that's just, we don't do criminal histories on felony FTAs.
oh, okay. So I don't know if you have any or not.
I don't. This was my first felony.
All right. I don't have any way to corroborate what you're saying, so I'm going to leave the bonds where they are, but, you know, you might want to bring in that information when you come to court so the judge won't think that you're just someone who runs out on your charge.
I don't understand.
You know, you can always bring some paperwork showing that you just got the hip surgery. That might even.
I mean, I could show you the scar. That's about it. I don't have
The scar?
the scar.
I believe you can. I've seen those scars before. My mother got that surgery. It's pretty wild.
Do you know when my next court date was going to be? Because I'm not going to be able to make the bond.
Do we happen to have any court dates for him? Okay, we'll check.
Because I thought I was going to get time served from what, so when I went back to court, from how long I spent already.
The new dates are not set yet, but it should be pretty quickly, I think. All right. You're welcome. I'm curious if he has a drug history. I'm like 11 years older than that guy. So if you do drugs, it adds up on you. Is this Mr. Morris?
Yes, ma'am.
Okay. Sir, this is case number, is this a 2001? Oh, shoot, you must have been about 20.
I was.
Okay. Oh, wow, it's an old violation of probation. You got a private attorney on this?
Yes, ma'am.
All right, it's going to Division 16. It's an old robbery with a firearm charge. Have you actually been out, or were you in prison that whole time on something else?
I've been out for the last 10.
Okay, and they just found this thing. All right, so they violated you back in, wait a minute, hold on.
Violation just came in.
No, this is more recent. Okay, so they had put you back on probation, or maybe you were still on probation after,
Yeah, I did 10 in, and then I had 10 out, so I did.
right, 10 in and 10 out, okay. All right, so, well, you got a no bond at the moment. It's alleged that you committed a battery by strangulation in Polk County back on the 18th of November. There might be more, but I don't always get the next pages on that with the allegation. Nope, here they are. Ag battery, deadly weapon, strangulation, domestic battery. So that particular battery and ag bat and cost of supervision. So go ahead and see the violation of probation judge on that. Did we appoint the public defender, or do you need a public?
No, ma'am.
You have a private? Okay. All right, well, they'll get you in front of the judge pretty soon.
No court date set?
What they tell me is within about a week, or
Within 7 days, so he's set for next week.
you're set for next week.
Yes, ma'am, thank you.
You're welcome. Oh, thank you. Is this Mr. Prophet?
Yes, ma'am.
Okay. We have all right, let's appoint the public defender. We have case number 2020 CF 55780 going to Division 19. It's a violation of probation on a burglary structure, currently at no bond, allegedly using intoxicants. on or about April 6th, including amphetamine. I think it was a urine sample. And there's another page of alleged violations, possession of drug, maybe a methamphetamine also, methadone, etc. And so that's violating your state probation. We'll appoint the public defender. Clerk here tells me you probably see that judge within about a week. And then in regard to 2002-1MM 3539, Division 61, we'll appoint the public defender, and it appears they've got enough information to file the charge of resisting without violence. The bond on that is $500.
Ma'am, can I say something?
You might want to talk to your lawyer instead of me because you're at risk of going
No, it's okay, I got
to
it.
prison on the VOP and you don't want to incriminate yourself.
I was just saying, there was a PTR bond before that. Was it amended?
What, for the misdemeanor?
The violation?
I don't think I've ever seen a PTR bond on violation of probation.
No.
I think you're engaging in wishful thinking. It's not a PTR bond, it's a no bond.
Oh, wow. Yes, ma'am.
Good luck.
Thank you.
Is this Mr. Robinson?
Yes, ma'am.
Okay, they want you to put that. They don't want any of those COVID germs flying around. Okay, let's see what we've got here. We've got a violation of probation on case number 2020 CF 9054. That's going to Division 10. We're going to appoint the public defender for you. Originally, it was a burglary charge, and the probation officer said that you failed to report as ordered back in December, moved from your last place of residence, allegedly, basically, absconding. So that's no bond. I think you'll see that judge within about a week. And then there's 2020 CF 12057 is a failure to appear on a bat Leo in Division 14. We'll appoint the public defender on that. Currently, that one's at no bond. I didn't look that one up, but if you've got anybody with access to the internet, they can look up the alleged facts on that case. Okay. Is it Cecil Punter?
Yes, sir. Yes, Your Honor.
Okay, thank you. And this young lady's been waiting here all afternoon. Thank you.
That's my wife, Your Honor.
I think she's gotten an earful, boy. She has listened to all of this. And was this better than TV? I mean, she has been hearing about all kinds of stuff that she's probably not used to. Well, we got a couple of out-of-county warrants. Only one?
I think he's.
Only one, Your Honor. Could I explain? Oh, sorry.
Well, but be careful, because it's out of county, so there's nothing I could do. I know I look like I have a judge robe on and everything, but I don't have any jurisdiction. Well, I guess I would in Osceola. But I generally don't change failure to appear warrants, but whatever the young lady wants to say, she's been here all day. I'm willing to listen to it. Is there a case number you guys want me to read out? 20MM3125 in Osceola? And so I guess it says it was a failure to appear on a violation of domestic violence injunction. Please arrest and place a hold. We will extradite, which means they would bring it back within a day or so because they're right next door and they're the same judicial circuit. We're appointing the public defender just to make sure nothing. Okay, ma'am, let's get you sworn in because you've been here. Like I said, I'll listen to whatever it is you want to say. would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you might need to speak up a little bit because you're behind that whole wall and the mask and everything. Or you might, what is it that you want to tell us? He's being held for failure to appear, so I think.
He was Baker acted, and I have paperwork.
I can't hear it. For one thing, both of y'all are talking. For another thing, I'm old. And for the third thing, you got mask on, so.
Can you hear me?
I can now.
Okay. He was Baker acted from the 19th until the 21st. And I have documentation to prove that he was at the facility, University Behavioral Center.
Okay.
Your Honor, I'm looking at the notes from the ASA on that case. The KPS was issued on the 19th. In their note, it says defense got information that the defendant was Baker acted, and the ASA met with the victim to explain that to her. So I believe he didn't appear it was supposed to be a trial.
Right.
Yes, Your Honor.
All right, so I'm still trying to hear everybody between the printer and everything else. Are you saying that you concur that he was in the Baker Act unit when he was supposed to be at trial?
Your Honor, that's what the notes that it looks like the ASA got told by defense.
By the defense?
That's what the ASA wrote in the notes, is that defense told her.
Did you want to find out this lady's identification and see if this is the person with the correct information or not?
Sure, Your Honor. May I inquire?
Yes, ma'am. She's the prosecutor, ma'am. First, we're going to need to get your name for the record.
Nicole Emerald James.
Okay.
And what is your relationship to Mr. Punter?
Fiance.
Okay. Your Honor, do you want to see any other paperwork?
Well, I would want you to see it first, and also maybe the public defender. You may or may not agree to the contents, in which case I won't even need it, but I certainly don't need to see it before you guys see it. That was really smart of you to bring documentation.
Thank you.
Your Honor, I looked over it as well as Ms. George. It does appear that he was at University Behavioral from 5/19 to 5/21. Trial was scheduled 5/19, although at what time he went in on 5/19. However, if he went in early, it was explaining why he was not there.
I'll take your word for it. He does have some criminal history, and I will tell you the truth, I didn't look up the underlying case. Is there anything you want to tell us about that, ma'am?
Yeah.
She isn't the alleged victim in that case.
You're not the alleged victim?
No, ma'am.
Are you
Sorry.
related to Mr. Punter?
I'm his fiance.
Oh, that's right, you did tell us that.
I believe the alleged victim, Your Honor, is his mother.
No.
My baby mother, my ex.
That's correct. She has a date of birth of 84.
Your Honor, I would ask that given the circumstances that you set a bond amount in this case, he was Baker acted during that time. And we just saw the proof of that, Your Honor, so he is telling the truth. So I would just ask that you set a bond.
Does anybody know anything more about the alleged facts of the original case?
Yes, Your Honor, I can give you a factual basis.
Okay.
It occurred on December 23rd of 2020. The defendant was served with an injunction in October of 2020 stating not to have contact with the victim, and the victim is to have temporary custody of their child. The victim advised on the date that she went shopping. She left her son at home. One of her friends sent her a text stating that her son was with his father, and they were concerned he wasn't coming home. The victim stated the defendant called her twice, and she told him to bring him back. The victim stated the defendant's current girlfriend gave her the address in Oviedo where the defendant and their son was. All events occurred in Orange County, Florida. So it appears that the domestic injunction, there was supposed to be no contact between the victim and the defendant, and the victim was to have custody of the child. And the defendant came while the victim was shopping, and it seems he maybe took the child.
That's a lie.
So the victim had to go return to try to.
Go get the child.
Yes, Your Honor.
All right. Okay. I'm sorry. So the state, are you in agreement that we should adjust this bond situation or not?
Your Honor, it doesn't look like he has failed to appear for anything during the pending of this case. However, the victim does have a right to be notified of it. And since it was a trial that he failed to appear on, I would just ask that you leave it no bond currently, so there can be an actual bond hearing on this, so they can reset it for trial. I'm scared it'll get lost on the docket if we give him a bond and it's not reset for something.
Your Honor, I think it's on, it's not right to hold him at no bond when he was, in fact, in a hospital. And we saw the proof of that, Your Honor. He has no failures to appear. And it seems that there may have been an issue with the child, him taking the child, but nothing that would show that he was violent towards the mother of his child during that incident. I just ask that you take all of that into consideration and give him a bond.
I know I've been studying this for a while, and I'm sorry, folks. That paperwork, did you hand it back yet?
It's in the.
Right, would you, I just want to look at it in case there's any more information. He evidently lives in Oviedo, so presumably the baby mother lives in Osceola.
Yes, Your Honor. Yes, Your Honor.
All right, so there's some distance. I want to look a little bit at the time, and it's part of what's giving me a problem here is the criminal history. Thank you. Okay, he's got medications prescribed. Okay. He's got appointments.
Yes, Your Honor. I go to all of them. I have one
It
coming up.
looks like some of the discharge stuff was a couple of days later.
I had to stay for 3 days. Whenever you're involuntarily Baker acted, you got to stay for 3 days.
It's always 3 days?
Yeah, so I was Baker acted the day before. I told the police officers I have trial, and they told me that they would inform the judge. They told me
they booked him into the Baker Act place in the morning, like 6:31. 0631 is AM.
It was the day before my trial.
He was in there.
It was in the nighttime.
It was in the nighttime, the day before my trial. And I told him, oh, I'm sorry.
All right, calm down. It's not helping me when I'm just looking at, trying to figure out the best I can do here. I appreciate that. Thank you, counsel. Can you do me the favor and attempt to email the trial counsel in that either division or somebody in the domestic division there?
The ASA that's on the case, Your Honor?
Yeah, or, somebody close enough.
Yes, Your Honor.
And does anybody happen to know what the bond was before he got Baker acted and failed to appear?
It was $250. It was $2,500 in Osceola. I paid $250 and I got out. That's how much it was.
$2,500.
2,500?
Yeah.
Okay. All right, let's, I understand the state's concern that the victim needs to be notified. I'm going to ask her to make an extra effort to let the lawyers know over there and give you the benefit of the doubt, although it's difficult because you do have some criminal history, sir, but you've actually really supported the fact that you were unable to come to court.
Yes, Your Honor.
And could we put that on the paperwork that he came to court with documentation that he was actually Baker acted at the date and time of the trial? So I'll go ahead and grant him a bond of this $2,500, which is what he had initially on that.
Thank you.
And I think it goes without saying that don't have contact. I don't know what your situation is in regard to custody and visitation, but that should be handled by either that court or whatever other court is managing it from the juvenile court perspective.
Thank you, Your Honor.
So other thing I'm going to say is follow court orders in regard to custody and visitation.
I do have, I'm able to see my case.
I'm just saying follow court orders, okay? Because I don't know what they are.
To comply with the injunction, Your Honor.
Comply with all court orders in regard to custody and visitation. We can't solve your custody and visitation thing. That might take 18 years for you to